Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, you guys, welcome back. Welcome back to another day of the Karen Reed trial. So at first I wasn't, oh, sorry, I'm trying to save this, not put on the screen. What are you doing? So initially for this one, I wasn't going to give it a trial day number because it's not really testimony. But then when I saw the Court TV and others are calling this day 27 of the trial, I was like, all right, that makes sense. Fine. Okay. I want to be in line with everybody else so I don't cause any confusion. So today is day 27, even though it's not testimony. This is all voir dire, and specifically all voir dire of defense expert witnesses, proposed expert witnesses. So what they are doing is these experts are getting tossed up there so that they can be questioned by the prosecution and by the defense to determine whether or not they can testify as experts in this trial. And if so, to what extent? What is the scope of their expertise, the scope of their testimony that they will be able to talk about? Also, how cute is that, right? Hi. For a while, I put that box out with a little like scarf or something in there to see if they would, if either of them would ever curl up in there, and they basically ignored it for like a couple of weeks, and now it's like she loves that spot. It's so great. Sorry, total divergence. Let's get back to it. So with this here, it doesn't always need to be the case that you have a full-on voir dire hearing for experts because, especially when we're talking about experts that are testifying to stuff that's pretty basic, right? Like stuff that we know that the science is relatively reliable, underpinning the foundations of their testimony. You've got a doctor that's going to talk about, certain wounds, a specific type of doctor who's going to talk about specific wounds. You've got, a psychologist that's going to talk about, borderline personality disorder, things like that. So, you don't necessarily need that. You just need like the expert CVs, so their experience and that kind of stuff. Full-blown hearing is interesting in this case because it could be that the prosecution, well, first off, I think the prosecution wants to do absolutely everything that they can to keep out these experts because, well, as we saw yesterday, the prosecution experts have been, well, generally speaking, pretty terrible for their case in chief. The Google experts are a bit of an exception to that in terms of the actual expertise that they have. The ability to communicate that expertise to the jury so that they can understand it is another story, but they at least have the expertise. The accident reconstruction expert, which is an expert that they really needed for their central case in chief in order to meet their burden. The Google experts are not required for their burden. This is like a separate issue. This is them playing defense against the defense. Here, their experts that testified to the various portions that they need to prove for their case in chief to meet their burden have been incredibly lackluster. And we saw that completely on display yesterday with the accident reconstruction expert who just got completely dismantled, completely destroyed by Alan Jackson before the end of the day. So, of course, they want to keep out as many experts as possible for the defense, because if the defense is using people that actually used physics and math for accident reconstruction and other stuff like that, then yeah, of course they want to keep them out because their expert will look even more incompetent and more just ridiculous. So of course, in my opinion, does the defense really need these experts? I don't know. Maybe I'm sure reasonable minds can differ, as our buddy Rick Hogue over at Hogue Law would say. But, the defense is already pretty ahead in this case. It doesn't hurt, of course, to have their experts on. But, I definitely understand why the prosecution would want to keep them out for a number of reasons. Now, the legal reasoning for why they say that they should be kept out was the timing of their introduction. Normally, experts have to be brought in before a certain date pre-trial so that both sides have the ability to exchange reports. Their experts can look at their experts' reports, and they can comment on each other's, and basically that can inform everybody's testimony going into it. So you need this advanced notice typically. However, with discovery, we've seen this come up in this trial also, this argument about, was something delivered too late? Was it delivered on time? This stuff can come up where there's new information that developed or that became apparent to both sides through no fault of anybody else's, that then one side wants to bring in. And so here, 2 of the 3 expert witnesses that the defense brought in, or that the defense is trying to bring in here, are actually expert witnesses that they first encountered because of the federal grand jury proceedings. So they heard about them through those proceedings. They learned that they were actually quite pro defense in this one, because I guess they're investigating essentially the prosecution here. So this is sort of like a triangle of interests here, where people are they've got these various interests with these different, there's the investigative body, and then there's the prosecution and the defense. So these guys over here, the feds, are kind of helping out the defense here. And the prosecution definitely doesn't want that in. I understand why, but is it legitimate? And the fact that this timing was a little bit later when those experts appeared, to me, says that it's probably fair for the defense to be allowed to bring them in. That's something that is very common in any kind of discovery matter. So, okay. So let's get into it, shall we? We've got 3 expert witnesses that we are apparently going to be hearing from today. I don't know if this is going to be a full day or a half day. So either way, I've got one stream set up. If there is some kind of a lunch break or something, probably what I'll do is I'll just sort of like put my screen up, my camera up on the screen or something. Maybe I'll have the fan spinning for folks or something. And then I'll just set it for one stream for the day instead of the morning session and afternoon session, which is what I've been doing lately. So we'll kind of play that by ear, and just kind of go with it, because I really don't know what the court is going to be doing in terms of timing today. And other than that, questions in the chat, let me know. We're gonna pause from time to time for some commentary, but if not, then we'll watch together and we'll comment together. So, anything else? Also, if you haven't done so already and you've been enjoying the coverage, be sure to like the video, like the stream, so that it pushes all of our content out to more people out there. The more engagement, whether it's in the chat or just hitting the like button or commenting or any of that stuff, the more YouTube recognizes that people are engaging with the content and liking it. And so that really, really helps to push it out. So if you are enjoying it and you want more people to see it and you want more people to come into the channel with us, definitely hit that like button for sure. And also, I will mention before we get started too, that we are very close to 246,000 subscribers, which is definitely very close to our goal of 250,000 subscribers. We're on the road. We're on the road to 250K. So really would love to hit that before the end of this trial, if at all possible. If not, I think we'll get pretty close, but if we can make it, that would be amazing. So definitely subscribe if you guys are enjoying it and you want to be part of that. All right, folks, let's get to it.
22117, the Commonwealth versus Karen Reed.
All right. Good morning, counsel. Ms. Reed. Are all of the witnesses here, Mr. Jackson?
They are, Your Honor.
I'd like to hear from Dr. Russell first. Are you both prepared to?
Your Honor, I'm so sorry. I could not hear you.
I would like to hear from Dr. Russell first. Is that her name?
Russell. Dr. Russell, yes. The order would be, I would propose based on scheduling Dr. Russell, Dr. Wolfe, Dr. Rentschler.
Okay, then that's good, because that's the order I prefer, so. All right. Do you have a CV for her? Good morning. Morning, Tori. Do you have a CV I could look at for her, please?
Let me see if I have it in my notebook. I thought I did. Yes, I do.
And she has not written a report?
She's not.
By the way, how ironic is it that Ellen Jackson was like, "I'm sorry, I didn't hear you, Your Honor."
All right, let's bring her in,
Everybody
please.
else to speak up.
Your Honor, before we get started.
Question in the chat: what is a CV? That's a curriculum vitae. It's the same thing as essentially the same thing as a resume. It talks about their entire experience, their education, their work experience. It's just it's a slightly different formulation from like a resume, but it's got a lot of detail for that. Experts always need to turn in their CV, their curriculum vitae, yeah.
Get an understanding. We started to say it at sidebar the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this seems to be unusual in terms of the timing of it.
The understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolfe and Dr. Rentschler?
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for
that-
Dr. Russell, what we're doing here today is there's an alleged well, there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have, the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't want to have to examine her concerning her full opinions, her full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
Well, we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the same.
1 week from the filing of the certificate of compliance.
Well, I don't know when I can't remember. My co-counsel indicates it was the day before trial.
Okay.
So during the course of, the trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to, and did, give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands, that's not my point. My point is not, I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The point is,
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call it that. The point is that
he's like, I've already Hulk smashed her, Your Honor. I don't need to Hulk smash her anymore. That's funny. It's funny that when she was like, I'm sorry, you did what? That he repeated exactly what he said. He didn't like rephrase it to say that in a different way. He's like, no, I did that damage.
good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery.
Oh no, what happened to the sound?
Seminal information about an expert that we did not know about, never met, never heard of. Within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert. And if she testifies, cross-examine her again after consulting with our expert. That's 2 bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on of her testimony because that's been provided. And I don't think Mr. Lally should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so I disagree. I'm going to hear from the Commonwealth on this. Is it Ms. McLaughlin or Mr. Lally?
Okay, so basically, just to catch you guys up in case anybody didn't catch all of that. So what she's referring to is a discovery violation. What I was talking about in my intro, basically before we started watching the proceedings, was that there are certain deadlines that have to be met. So what she's talking about is Dr. Marie Russell. This is the one of the 3 who is not one of those that testified in the grand jury hearing. And so what she's saying is, okay, maybe those other 2, you didn't know about them. So the deadline is not really a factor for that one. It's not a discovery violation for them because you didn't know about them. You can't be held responsible. She hasn't said that, but that's what I'm assuming is implied here from the fact that she's focusing on Dr. Russell for that. So what she's saying here is essentially, you knew who this person was, you knew about her, you didn't, provide discovery as to this witness so that the other side could have advance notice, meet the deadline. And so she's saying like, there's a potential discovery violation. So it seems to me that, actually, let me do this. It seems to me that of the 3, the one that's the most likely to be excluded here is Dr. Marie Russell, the first one that she wants to hear from. So, for Jackson, what he's saying is he's arguing with her about the extent of this voir dire as to Dr. Marie Russell. The other 2, he's like, I haven't even had a chance to talk to them, and that was part of the reason for their argument for the fact that they didn't mess with any kind of a deadline for the discovery deadlines, is because they're like, this is so new that we haven't even had a chance to actually voir dire them ourselves, to talk to them about what exactly their testimony is. They know basically because they know what they testified to in the grand jury hearing, but they haven't had a chance to have like a one-on-one conversation with them, which is like, it is a little bit wild to me to be. It does feel a little bit like they're flying by the seat of their pants on that. But like I said, they do have prior testimony that was under penalty of perjury. So, most likely, and they were looking at the exact same stuff. So it's going to be about the same as what was already testified to. So Dr. Russell, however, is different. She is correct, Travis James. She's the dog bite expert. So she is the one who has a lot of years as an ER doctor and also some years as a consultant for the LA County coroner. So she has quite a few years of experience there. She's kind of like this, like a dual threat kind of to the prosecution because of that, because the argument by the prosecution for one of the arguments for why she shouldn't be able to testify here is because they're like, well, she's an ER doctor, and ER doctors look at wounds on live patients. And that is different than the way that wounds will appear on dead patients. And that is true. That is true because you don't have circulation that's going anymore. There are all kinds of different factors that wounds will look different when it is appearing on someone who has already passed away versus someone who still has their heart beating and their blood pumping. But I would imagine what the defense is going to say is no, she also has experience as a coroner or at least working as a consultant for the coroner's office doing this kind of forensics. So she absolutely is qualified to be able to testify to this. This is what I expect them to argue anyway. So now what he's arguing with Judge Cannone is, hey, look, we've got, all kinds of stuff that we of course, are going to be planning to testify or have her testify on. However, for the purposes of this particular hearing, the scope should just be on what exactly her qualifications are, whether she's qualified to provide testimony on this particular subject, in this case, as an expert. Judge Cannone disagrees because she thinks that there's a potential discovery violation. And so I think that what she wants to know is how soon the defense team probably knew about her and talked to her and got her opinion on things and things like that. And so I think that probably what she wants to do is basically to find out, did they know about her? Did they have her information? Did they, essentially have her report, her opinion, etc.? And therefore, were they in a position to have been able to present her on time before the deadline? Now, his argument here has been, we can't present an expert when we don't have the underlying information for the expert to use to render an opinion. How can we possibly do that if we don't have all of the underlying discovery? And so that's one of the things is that that's one of the reasons why there's actually a different deadline for expert discovery as opposed to regular discovery. Those are two different deadlines, and it's because of the fact that you need everything to basically be in, or at least mostly everything to be in order for that expert to be able to write a report, give an opinion, figure out whether, what their thoughts even are on this. As we saw yesterday in day 26, that can be a huge problem when a supposed expert doesn't look at all of the information. So his argument here is also very interesting. He's definitely making the best argument that he possibly can, which is that, look, we didn't have everything. So how can the expert be expected to render an opinion and write a report and meet those deadlines if the prosecution isn't following their assignment? This is like, I feel like this is I've got Clueless playing in my head, where we've got Cher debating against Amber, and Amber's like, I'm sorry, but if she can't do the assignment, or if she can't do her assignment, then I can't do mine. That's essentially what the defense is arguing here. So we'll see. But it sounds like the judge is basically being very, very stubborn, I guess, on this point. Like, she's already made up her mind, and she's basically saying, no, your witness is going to be testifying about this particular issue. Okay, that was a little bit longer than what I wanted to sum up that whole back and forth, but essentially that's what that was. So let's see what Lally's going to say in response.
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was and I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
No, Your Honor, I said this at sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Maureen Russell 3 days after I learned about her.
That audio feed cutting out is killing me.
I had never heard of her. I didn't know who she was. We made contact. I determined that she would be useful for the jury.
Okay.
In terms of specifically the injuries to John O'Keefe's arm. I then had one conversation with her, then immediately within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days into trial. That's not what I said.
Okay, so that's good information to know for this analysis. Is, you know, one of the issues is, when did the defense team know about Dr. Marie Russell? And so right here, we hear from Alan Jackson that he's like, no, I had just found out about her. I didn't know who she was. I didn't know about her expertise. I didn't know anything about her. And I found out about her, immediately got a report from her, immediately turned that over to the prosecution. So there's no discovery violation here. So interesting, whether the judge decides to side with the defense on that is another matter. I don't think that she will, based on what she's already said, but let's see what she says.
All right, but you were ordered to do it. Ms. Giannetti, what was the date? What, you had 1 week from when?
The day before trial. So it would have been, I believe, April 15th. So what we knew as of that day, we were required to turn over.
Uh-huh.
All right, I need to take a quick recess.
Okay.
What? All right.
She needs a quick recess. Okay, so maybe she's going to take it under consideration. Let's see here. Maybe it was a good thing that we had a little bit of a delay. Okay, no, we're still going to be behind when she comes back. All right. Interesting that the families are there even when the jury's not there, just for the voir dire. Reed's family there. You guys
The Commonwealth's motion.
picked up on that.
All right, so the Commonwealth has moved that I exclude the testimony of Dr. Russell
And that's
based on a
Donkey's family.
violation of the reciprocal discovery obligations of the defense. So I do find that there is a violation of the reciprocal discovery obligations of Rule 14. And I'm quoting from the notes, the importance of this, the reporter's notes to the old rule. And as you all know, we're in the process of updating that rule. But the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense.
I really do wish that she would speak up, because she suddenly got very quiet. Also, so what she just ruled was there was in fact a Rule 14 discovery violation by the defense. And so now she has to say, what's the remedy? What is the remedy here for for this violation of the discovery rule? I don't know that I agree with that, to be honest with you, because from what they argued, that they're like, we didn't actually know about this person. I guess a follow-up question to that, however, would still be, were they in a position to have found out about this person, to have, reached out? Like, was this because they were slacking off, or because they were, meeting other deadlines, or I don't know, something? Essentially, were they in a position to have met that deadline otherwise, all things considered? So, yeah, I don't know. But yeah, I don't know that I agree with that discovery violation ruling from her, but we'll see what she says for the remedy.
So what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness, Mr. Jackson.
Uh-oh.
The alternative is she doesn't testify. So the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire, and they can ask her anything that they think they need to ask her. So those are the parameters.
So that is probably going to be ultimately what the remedy is, because when we have a discovery violation that happens, it's not automatic that it's going to be excluded from the testimony. There are a number of remedies that you can put in place in order to ameliorate the issue, right? Because what you have here is, when you have a discovery violation of any kind, whether it's about expert witnesses or regular discovery, just, sending over documents or, like getting in the way of depositions happening or things like that, you have a discovery violation, and the judge basically is looking at, okay, one of you is being unfair with this process. How do we shift things so that we rebalance it so it's fair again to both sides? And so the goal for the judge is not to be overly harsh to either side, including the side that they've determined has violated the discovery rules. The whole goal here is to rebalance the field and make things fair again. Does that mean that it's monetary sanctions because the other side had to spend so much money and resources and time in order to get that information from them? Maybe that's the remedy. Maybe the remedy is there's simply not enough time for them to be able to do what is necessary to cross-examine on a particular topic, and so therefore it's all it's all excluded. That's what happened with the ring footage with the last expert, right? Because literally they sprung it in the middle of direct examination. There was zero warning at all to the defense. And they're like, we can't prepare for this. Like, we've already done our cross-examination. Like, we're supposed to cross-examine him in like 2 minutes. Like, how are we supposed to prepare for that? Like, that is like a proper remedy there. Or here, it seems like what the remedy is she says, okay, they didn't have enough time to really prepare for this because of the fact that this was presented too late to them. However, the remedy here is now they get to know, but do a full voir dire, get some advance notice on what her testimony will be, and then therefore, like, that's their preparation for this particular expert witness. And so folks asking, is this, I saw somebody in the chat, is there, is this them getting 2 bites at the apple, right? And that's what Jackson was arguing before is basically like, well, okay, so Lally's going to get to cross-examine her now and then cross-examine her later, and basically like essentially shore up what he would be doing on cross-examination, whatever mistakes he may make, he can do it better the second time around. There's 2 tries here. And so that's the argument there. But Judge Bev has decided, well, no, like this is, they would have had advance notice as to what she was going to be testifying about, because she would have gotten they would have gotten a report. Their experts would have gotten a report, and, and therefore, like, they would have been able to go into this without surprises. They need to be able to know exactly what she's going to be testifying to so that they can properly prepare for her cross-examination. So that's the point that she's making here in trying to even the playing field again. Okay, let me get some questions here and then we'll continue on. I'm sorry if this is going a little slow for you guys, but I want to make sure that people are understanding what's happening here. Dan Luch, thank you so much for the question. Maybe Alita can give us a quick rundown of what is happening and what we can expect from today at the start of the stream. Yes, okay, I hope I did that enough for you guys. Honest Mike question, can the defense phone expert watch the other testimonies to specifically respond, or do you think they won't even call him now? No, they absolutely can. Experts can watch the other side's testimony, especially like the testimony that is relevant to their stuff, because like I said, they are allowed to and supposed to read each other's reports, know what the other side is arguing, be able to combat the other side and what they're arguing, and basically say this is why they're wrong. So that includes testimony. They're allowed to sit in on the testimony, whether that is in person or like watching through the streams, things like that. Like, they're allowed to. That's one of the benefits of being called as an expert as opposed to a lay witness. Lay witnesses can, generally speaking, cannot listen in on any other testimony because we don't want them to be able to line up their testimony, because what they're testifying about is things that have happened in the past. The who, what, when, where, how, why. Well, no, not exactly. Sorry. Not the who, what, when, where, how, why. That's more expert testimony. The 5 senses that already happened, right? So you don't need a lay witness to have listened to the testimony of anybody else, because it shouldn't matter what anybody else testifies. What happened, and that's what that witness is testifying about. In fact, it's dangerous to have them listen to that because they might line up their stuff, whether they intend to or not. The Rubber Duck 77, Legalbytes with voir dire. More is let in with no jury, so should be less objections, right? There could still be objections just to get them on the record. I mean, we'll see. We'll see how this goes. Also, Joshua, thank you so much for gifting 5 Legalbytes memberships. Very kind and generous of you. Genergy, KJ Height, Shannon, Bluebell, Valerie Levasseur. You have all been gifted memberships by Joshua. So welcome back to Bike Club. Very happy to have you guys here. Joshua, thank you so much for supporting the channel. You're helping to keep the lights on and keep things running around here so we can devote all these resources and time and everything to these trials, the live streams, the recaps. It all takes so much. And so thank you. Alrighty. Elena, seems like some rules only apply to the defense, not the prosecution. It's really annoying and confusing. Keep in mind, however, yesterday there was the expert testimony about the ring footage that was kept out entirely. That was the remedy, which is a pretty harsh remedy in my opinion, but it was appropriate in that situation. Triker, a question. Lally seems to be stalling for time because Bev has already set a time on this trial, which really feels to be in violation on Karen's due process rights. What are your thoughts? I mean, I haven't been following the pre-trial litigation beforehand to really get a good feel on all of the discovery that's been continuing to pass back and forth between the two teams into trial. To me, that seems highly irregular, but it seems that both sides have actually done it a bit. And both sides are complaining about the other side doing it, of course. It is irregular, but I don't know. I don't know. Yeah, I'm not a fan, to be honest. I like everything being out in advance, so that everybody knows what's out there before you even get into trial. But that's just kind of how things have played out here. I mean, and in terms of Karen's due process rights, there is a greater burden on the prosecution to not violate those, right? Because the state doesn't have any due process rights. The state really doesn't. The rights that we care about are the defendants. So, where there's a little bit of a weight that should be given to one side or the other, it should be the defense. That's how we all individually should be feeling, because theoretically any one of us can find ourselves in the seat of the defendant. And if we are there ourselves, or we have a family member or a loved one or a friend that is in that seat, yeah, of course, we want to make sure that the system is working properly and that everyone's rights are protected, whether or not we like them. The Rubber Duck 77 question, could it be, even though the turned over as soon as they could, it was the type of info the defense gave wasn't enough? That could be too. Stephen Horton, question, if this is the remedy, does it mean they will testify in front of the jury? So yeah, I mean, ultimately that would be it. I think Judge Cannone hasn't officially said if this is the full remedy or if she's going to decide more, like whether to exclude, for example, because that's ultimately the request in the motion, is to exclude the testimony. She hasn't said whether she's going to do that or not, but it seems to me that this would be the remedy, is the full voir dire. Defense doesn't want it. Of course, they want to keep, as much information that is, not necessarily information private, because with expert witnesses, both sides should be able to have access to what it is that the opinions are going to be, what they base it on, all that kind of stuff. But I also understand Jackson's reservations about them being able to essentially cross-examine her twice. Jerry Roth, so a discovery violation is okay for the CW, but not the defense. Remember, keep in mind that there was testimony that was kept out yesterday. And that was prosecution friendly testimony that was kept out. So it's not always, I know it feels that way oftentimes with this judge, but it's not always the case that the determinations on these kinds of rulings are always anti-defense. I haven't found that myself. Phantom Split, say that this witness brings in novel evidence and testimony. Can Commonwealth find their own witness to respond with on rebuttal? If so, how does defense respond to rebuttal? They would, so most likely what they would do is they would bring back their own expert to respond on rebuttal. This is what happened, like, in the Depp trial, for example, when we had the experts on psychology talking about talking about PTSD versus borderline personality disorder and these kinds of things. So we had expert witnesses that were talking about these various diagnoses and whether or not they existed in this person or that person, you know, and all the reasons for it. So gosh, what's her name? Dr. Curry. Dr. Curry testified for Johnny Depp. And so she was in the prosecution's plaintiff's case in chief. So she was in the first chunk of the trial. Then you had the expert witnesses for the defense that she was able to sit in on and watch and listen and analyze. Then the then the plaintiff side, Depp side, they had their rebuttal portion where she came back and was able to respond to the testimony that came related to those same diagnoses. So that's how that would work, is you've got one expert against another expert, and then they come back around and testify again on rebuttal. So that's how that would work, as opposed to like calling an entirely new witness, because that all kinds of weird issues can come up with that. Okay, let's continue on. Also, yeah, we don't have a poll in here. I guess we can start a poll. I'll get that started, and then I'll start the next part of this hearing, and then I'll get a poll in the chat. Okay, let's go.
As
long as I know the guardrails, that's fine. Just to close the loop on the record, my understanding, and this Little can probably speak to this more intelligently than I can, but during the middle of trial, there was a witness that we had never heard of, we did not know and didn't have a report for.
Who is that?
Dr. Fowler, Faller.
Okay.
If the court remembers, he's buried in the middle of about 75 witnesses. So he testified to alcohol levels, et cetera, and protocols at which institution? At Good Samaritan. And we didn't have that information either. We didn't throw a fit. They said we were going to provide this information in a timely fashion as soon as we know that we're going to call him. He's got to be on our witness list. We didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what we were doing as well. And by the way, I would note that the notes and the report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't turn over.
No, I'm not saying that. It's just, this isn't as if it were something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
All right, so that's the big difference. So why don't you go ahead and call her?
Okay. May I be excused to call her?
Yes.
Sound is boosted here. Let me turn my own mic down, and then you guys can turn up your own YouTube volume up. That way it'll be balanced. Because right now I do agree they are very quiet. Also, Deputy Faison Cook, thanks so much for gifting 5 more Legalbytes memberships. So kind and generous of you to do that once again. So Sarah JH, Darth Horse, Owen Fender, Sandy F, and P, you have all been gifted memberships by Debbie Faison Cook. So welcome, or welcome back to Bike Club. So happy to have you guys here. Debbie, thank you so much. Helping to keep the lights on. Okay, here she is. On voir dire, Dr. Marie Russell.
Do you solemnly swear the evidence you give in the court, the case now is the truth, the whole truth, and nothing but the truth, so help you?
I do.
So I'm going to ask you to keep your voice up. Speak right into that microphone, doctor, okay?
Yes.
Thank you. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. Good morning. Could you please state your name and spell your last name for the record?
Yes. Marie Russell, Russell.
And I'm going to echo what the court just indicated. The air conditioners are on, so please keep your voice as elevated as possible and maneuver the microphone however you need to, okay?
Okay.
Dr. Russell, what do you do for a living?
I am a retired emergency physician and forensic pathologist.
And tell me what education you have, going all the way back to the beginning, that qualifies you as an emergency physician and former pathologist before you retired.
Okay, well,
When he was like, go all the way back to the beginning because she's retired now at this point. It's just so funny how she's just like, the reaction was like, oh boy, the whole beginning, like the beginning. um, okay, so yeah, I'm so sorry, guys. That I know that the sound is low. I've got my volume all the way up. I tried to turn myself down to balance myself out. I hope that has helped. Let me know if it's still out of balance. I've got the sound boosted as much as possible. I really wish that Jackson would just use a mic or something or really project. Yeah.
uh, I've had about at least 16 years of formal education beyond high school. Initially, I started at MIT, where I did my pre-med courses. I had always wanted to be a physician, and so I went to MIT for a year, took pre-med courses, and then I had an unusual life event in that my mother came down with cancer, and she subsequently passed away. During the time away, so I took some time off from school. During that period of time, I decided to explore another interest of mine, which was law enforcement. And so I took some courses in law enforcement, and I became a full-time police officer here in Massachusetts.
What years were you at MIT?
I'm sorry, that is such a cool background already. Um, okay, also, is this volume better? This balance between the two? Let me know, guys. Either way, I'll continue to balance until you guys say that it's okay between me talking and them talking until somehow someone on their end figures out that they need to boost the sound again.
That was 1972 to 1974.
Did you go to the police academy?
I did. Once I became a police officer here in Massachusetts, I attended the Boston Police Academy where I graduated.
What year was that?
That was in 1977.
During the course of your training as a police officer, did you have any specialized training in hit and run and accidents and investigations?
Yes, I did.
And which agency did you work for as a sworn peace officer?
I worked for the city of Malden full-time for 7 years.
That would be from 1977 to 1984, approximately?
Correct.
During that time, did you continue your education in any way?
I did. I took as many courses as I could from the Massachusetts Criminal Justice Training Council, which included a several-day course in hit and run accident investigation. I took courses in forensic photography and numerous other things. And then, and I also at the same time continued to go to college, and I did that part-time, where I eventually got a bachelor's degree of science in psychology with highest honors.
What institution was that from?
That was from Northeastern University.
And that was a Bachelor of Arts in Psychology?
I think it was a Bachelor of Science.
Got it. Subsequent to your Bachelor of Science degree from Northeastern, did you also advance your education further, formally?
Subsequent to, so I decided that I did want to pursue a medical career. And so I then attended medical school, University of Massachusetts Medical School full-time for 4 years.
Did you ultimately get a degree, an MD degree from UMass?
Yes, a Doctor of Medicine degree in 1987.
So you were there from 1983 to 1987, is that right?
That is correct.
And did you do a residency?
I did 2 residencies, actually. Most people do 1, but I did 2. I did my first residency was a combined internship and residency for 4 years. And I did that in Los Angeles at Los Angeles County Medical Center, which is a very big trauma center and what I would consider the Bellevue of the West Coast. Very busy.
You say that just because of the volume at USC Medical Center?
That is correct.
Is it one of the busiest medical trauma centers in the country?
Yes.
You were there from 1987 to 1991, is that right?
Yes, I did my ER internship and residency during those years. Yes, there.
During that time, were you seeing patients?
Oh, yes,
You were treating patients?
lots of them.
You were attending to patients?
I was a trainee, so I was seeing as many patients as we could. There was always a waiting room full of patients, and yeah, so I saw many patients during that time period.
Whoa.
You indicated a second residency. Tell me about that.
Okay, that volume just turned way up on me. Okay, I think that they fixed the volume issue on Court TV. So, let me turn myself back up. Let's all, I'll give everybody a moment to adjust their volume. I'm going to turn myself back to normal. So, turning it up, 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 and we're back to where I started, which was at 100%. Okay. Now everybody turn your volume down overall on the stream if you've turned it up, just to make sure no one blows out their ears. And then we're going to get back to it. Okay. I want to make sure I'm not harming anyone's hearing here. Okay. I'm glad they fixed that because that was very frustrating for a bit there. Okay. Let's go.
Okay, so I
didn't
still
turn it down enough.
realized I had an interest in forensics, and so I decided that I wanted to also train in forensic pathology. So I did a second residency in anatomic pathology, 2 years, followed by forensic pathology fellowship at the Los Angeles County Coroner's Office for 2 years.
And the years, if that's 4 years, that would be from 1991 to 1995, approximately?
That is correct.
Tell me what your experience was as a fellow at the Los Angeles Coroner's Office, Los Angeles County Coroner's Office.
Yes, well, it also was a very busy coroner's office. And so every day there would be cases. I probably did at least 2 cases a day, most days, and plus conferences and educational opportunities. But the interesting thing about being a fellow is they try to give you a wide assortment of cases. So, for instance, I not only saw numerous victims of gunshot violence and stabbings, but I saw numerous victims of motor vehicle accidents and natural death, overdoses. And then if there was an unusual case, it usually went to the fellow.
I can totally picture that. Having grown up in Southern California, Los Angeles has a massive population. So USC Medical Center, UCLA Medical Center also is going to have something like that. But USC Medical Center, that was her experience and her time during this time period. This is something that absolutely she would have seen a lot of stuff, a lot of stuff, because Los Angeles is massive. There's all kinds of crime, injuries, accidents happening all the time. So yeah, absolutely 100% reliable on that one. I'm sure she has plenty of experience on that. What else was I going to say? Oh, also there are some people questioning or asking in the chat about, who like she keeps looking at the jury. Is the camera guy showing the jury? So there is no jury in the room today. This is all outside the presence of the jury. So the people that you see there in the jury box are journalists. They're actually allowed to sit there today to watch and obviously write about or comment on or what have you, report on the trial proceedings. So that's who she's making eye contact. It's probably just habit as somebody who has testified as an expert before on these things, is just when there's a jury box and there's people in there, you turn and you look at them. Or, I mean, she's actually kind of, looking at making eye contact with a lot of people there, but don't worry about anybody being shown. That's not a problem. None of those are jurors.
Because the fellow was also being supervised. So
Did any of those unusual cases, and we'll get more into this in just a second, but did any of those unusual cases include animal attacks?
yes,
Did you become a professor, an educator at any point?
yes. So during my 29 years at LA County Hospital, during the last 25 of those, I was a assistant professor or an instructor, but mostly an assistant professor. And what that meant is that I was responsible for overseeing the care that was provided by the interns and residents. So when a patient would come in into the hospital, the emergency room, they were oftentimes usually seen by the intern or resident, and then I would go and subsequently see that patient also. So, and that was in addition to my own cases. So I'd see my cases and their cases.
And that was at LAUS.
And I love an expert witness that has experience as a professor or an educator, because you know that they are used to breaking things down and explaining things to people who are not already knowledgeable about the subject. That's the whole point that you go to school, right? Or that you go to learn about something, is to increase your education on it. So this tells me that she's probably going to be a very good expert witness in terms of her explanation of her expertise. So that's, I absolutely love it. Also, is it just me, or does she seem like the kind of expert witness that is also going to like explain everything, and then at the end of the day invite you over to like make some chocolate chip cookies? Like, I feel like I want to have chocolate chip cookies with her after this.
Correct?
That is correct. And
Can I ask a quick question?
Yes.
LAUSC, for those of us who are not necessarily familiar with it, is that associated with the University of Southern California Medical Center?
yes.
That's the school, in other words, the site.
Yes, so it stands for Los Angeles County / University of Southern California Medical Center.
And that's where you were an assistant professor for the majority of the rest of your career.
Correct.
Were you also an assistant or an adjunct professor at Cal State Los Angeles?
Yes,
Okay. For how long were you an adjunct professor there?
I believe that was 4 or 5 years. And I taught criminalistics, forensic medicine there.
As an attending physician in the ER, in other words, a supervising physician in the ER, can you tell us what some of your duties and responsibilities included, especially as it pertains to trauma? And then I'll get more specific in just a second.
Okay, well, so I would oversee the care of all the patients that came in during a particular shift. And that would include medical patients and trauma patients. And as I mentioned, it was a very busy trauma center. So we had lots of trauma patients, including the types of violence I described earlier that I saw at the coroner's office, but lots of motor vehicle accident victims, because there was a highway there right nearby. There were a couple of highways, and so.
Ma'am, there are more than a couple highways in Los Angeles. Can confirm. I mean, this calls for. I'm sorry to interrupt, but this calls for something.
I know a shortcut through El Segundo. Take the 105 West and exit on Cabo. When you see the Zanko chicken on the left, turn right. Take Venice and follow it all the way down. Then you're in Marina Del Rey.
I did not anticipate this clip coming in to a context like this in this trial. Like when I was uploading that clip to StreamYard, I never once thought, hey, this is going to be useful during a voir dire of an expert witness. But here we are. Okay.
Yeah, so a wide variety of accidents.
Did your supervision include assessing, diagnosing, and treating patients?
Correct.
In terms of the middle part of that, diagnosis, was part of your job to determine the cause of injuries, or to at least assess the cause of injuries?
Yes, and I took that on a little bit more because I was interested in the forensics aspect of the injuries.
The forensic aspect?
Yes.
Okay. During your time at LAUSC, even after you left the Los Angeles coroner's office as a fellow, did you continue to stay in contact with the coroner's office and have a relationship with the coroner's office as a supervising physician?
I continued to stay in contact with the coroner's office, and I used to attend their conferences as often as I could, not as a supervising physician, but as a physician and a graduate of their program.
During your tenure at LAUSC, did you ever become the director of any programs at LAUSC?
Yes.
Does that include the director of Center for Life Support Training?
Yes.
What years was that, if you remember?
I don't remember. That
The early 2000s, late 90s?
Yes, that sounds about right.
Okay.
And we would conduct lots of courses, including trauma, life support courses.
Did LAUSC incorporate a quality improvement program
Yes,
within their institution?
yes,
Did you become a director of that as well?
yes,
So you were director of Center for Life Support Training and director of LAUSC Medical Center Quality Improvement. Is that right?
the quality improvement was for the emergency department.
All right.
Yes,
And did you also become the director for jail medical services?
yes.
What is the association between LAUSC and the very, very expansive jail system in Los Angeles County?
So LA County Hospital was unique in that they, many, many years ago, developed a jail, what they called a jail ward, which was a combined inpatient, outpatient, and ER. So there was a dedicated jail ER. And that has been in existence for probably about 70 years now. And patients that were placed under arrest by either LA sheriffs, LAPD, California Highway Patrol, or any of the municipal agencies in the area, and I think there were about 70 or more municipal agencies, could bring their patients to the LA County Jail Ward where the patients would get treatment.
Ultimately, you became the director of that entire program, correct?
Yes,
Did you also work with the State Medical Board of California in any capacity?
yes.
Tell us about that.
For about 7 years, I worked part-time for the California Medical Board as a physician assigned to one of their enforcement teams. And I did that 1 day a week, and I did my other job at the county hospital the other 40 hours a week.
So you didn't take off time from your duties as an ER physician, as an emergency physician. This was in addition to you being an emergency physician.
That is correct.
Did you hold the title?
Ma'am, can you please show the court your time teller so that we can all understand exactly how you had time for all of this stuff? Like, this woman has been just working nonstop in this field. It's amazing. I'm incredibly impressed at this point about, with her massive body of experience in this entire field, and also the crossover with forensics, with law enforcement and everything else. Like, she seems like an amazing expert witness to have on the stand in this particular case. I really hope that she's not excluded, just so that we can hear from her and hear her analysis of this case.
Of Chief Medical Executive for the California State Prison System, specifically at Corcoran.
Yes.
Tell us about that.
So I retired from LA County Hospital, and I went on to move on to the the California Department of Corrections and Rehabilitation.
And what year was that? Did you make that transition?
So 2018 is when I started for the state prison system.
Okay.
And I worked there for 5 years as director of their medical service in Corcoran.
I'm sorry. So for that prison, within that system, you were the chief medical executive for the entire agency, correct?
That is correct.
All right.
For the entire prison.
Understood. Are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes.
Are you a member of the American Academy of Forensic Science?
Yes.
Do you have any publications in the area? And I'm going to be very specific because you've been relatively widely published. Is that right?
Some people would say yes. Some people would say no.
I feel like she's being humble, probably. She's probably been published in a ton of journals and a ton of peer-reviewed articles and whatnot.
More than a couple of publications.
Correct.
And peer-reviewed journals, correct?
Yes.
I want to focus your attention on animal injuries. Have you been published in the area of animal injuries specifically?
Yes.
Do you recall those publications?
Yes, they had to do with law enforcement dog bites.
Did you draft an article or co-author an article called Managing Law Enforcement Dog Bites in the ER?
Yes, I was a co-author.
1996?
Sounds right.
And that was a peer-reviewed article?
Yes.
Ultimately published?
Yes.
And ultimately available to be cited by other doctors and studied by other doctors, correct?
Correct.
Did you also author or co-author an article entitled Law Enforcement Canine Dog Bites, Injuries, Complications,
No
and
way.
Trends?
Yes, I did.
Was that in 1997?
Sounds right.
Was that also
So 1997 she was published in like a massive book like that. Wait, so let's do the math. So 24 plus 3, 27 years ago, almost 3 decades ago. Yeah, do you think maybe she has some expertise in this area? Yeah, I think so. This is it's just hilarious to go through this also right on the heels of yesterday's testimony from Trooper Joseph Paul, right? It really just makes his status as an expert witness just look even more laughable as a result.
peer-reviewed?
Yes.
And that publication was also available for other physicians throughout California and throughout the country to refer to for the study of animal bites and dog bites, correct?
Dog bites, yes.
Dog bites.
Oh my God.
Concerning animal injuries, during the course of your professional experience, how many patients have you seen, diagnosed, and or treated with animal injuries, including dog bites and scratches, if you had to estimate?
Many hundreds.
Would you say it's over or under 1,000?
I would say it's over 500. I don't know because we didn't keep really good records back in the earlier days.
But it's safe to say you've seen hundreds and hundreds and hundreds of dog bites and scratches.
Yes, in my 29 years at LA County Hospital, yes. And my dog bites I took care of and dog bites that the residents took care of, yes.
And you've even published articles and studied, not just seen them, but studied dog bites and dog wounds, correct?
Yes,
Have you qualified as an expert previously in other courts as in emergency medicine?
yes,
Have you qualified as an expert in other courts in forensic pathology and wounds?
yes,
Has that been in both state and federal court?
yes.
Doctor, were you asked to review certain materials related to this case?
Yes,
And that was in furtherance of coming to, if you could, come to an opinion or a conclusion about injuries to the victim in this case, a person by the name of John O'Keefe.
yes.
What did you review in anticipation of your determining whether or not you could come to an opinion or a conclusion?
So I reviewed hospital photographs, autopsy photographs, an autopsy report, grand jury testimony from the medical examiner in this case. There may be some other.
Based on
I just want to ask about that. Do you have notes with you as to what you reviewed?
No.
Okay, so when you say there might be other, you don't.
Well, if
If he tells you what you reviewed, you'd know it.
I would recognize it.
All right, but I want to hear it from you. You
Oh, I
you
see.
don't know of anything else
Okay.
that you've reviewed? This is sort of important, Mr. Jackson.
Okay.
Can you think of anything else, Doctor,
No,
besides
autopsy.
these?
Autopsy photographs, autopsy report, neuropathology report, toxicology report, and the grand jury testimony.
Okay, so as you recall, the items that you reviewed include an autopsy report by Dr. Scortibello, correct?
Yes,
A neuropathology report by a doctor named Stonebridge, correct?
yes,
Toxicological reports associated with the autopsy,
yes,
grand jury transcripts from Dr. Scortibello,
yes.
photographs of evidence items, including a gray sweatshirt,
Oh, yes, yes,
and autopsy photos that were taken attendant to the actual autopsy.
yes, and photographs that were taken in the hospital, and I reviewed the hospital ER record also.
So in addition to what you just listed, there's also hospital photos separate and apart from the autopsy photos, is that correct?
Yes,
And those hospital photos showed the injuries to Mr. O'Keefe's arm, is that right?
yes,
And you also reviewed emergency room records that are attendant to his initial acceptance into the emergency room on January 29th, 2022, correct?
that's correct.
Based on your review of all of those materials, were you able to confidently come to any conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm?
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's combination of both what I consider bite wounds and scratch wounds on the arm. There were also some puncture wounds in that shirt.
And are the
So I'm sorry, puncture wounds in the shirt?
Puncture holes
Okay.
in the shirt.
and on what do you base the opinion that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. There are different angles on the arm and different locations on the arm, and but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, you know, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
I also love that Indy just walked in for this portion of the voir dire. It's like she knows that she's talking about dogs now. And Indy's like, well, let me listen in. I also want to now take a look at her jaw as she's describing this.
I'm going to have just a moment, Your Honor.
Yes.
Also, let me get some super chats here. XMO, thanks so much for the super chat here. She gives strong Kathy Bates vibes. I agree. I like it. Just because, in case anyone watches Murdoch series, she almost sounds like a real life Dr. Julia Ogden. I don't know that series, but I guess I'll have to check it out. XMO, also, thanks for the super chat. She's awesome, most likable and professional whole case. I really like her a lot too. Heather Miller, thank you so much for the super chat. Is there any way the judge, oops, sorry, don't want to be interrupting the testimony. Is there any way the judge won't allow this testimony? There is a possibility. There's a possibility that maybe she says that this voir dire is not enough of a remedy and that it should be outright excluded. So she hasn't really made her determination yet at this point, but it seems to me, I have a feeling that this may end up being the entire remedy, is giving Lally, giving the prosecution the opportunity to ask her literally anything that they want, so that when she does testify, they can be fully prepared for it.
Doctor, I'm going to show you a series of photographs. May I approach you?
Yes.
Okay, and also the photographs here that they are going to be talking about, I don't think that they are going to be putting it up on the screen. Actually, it does look like the screen is on, but there's no jury to show. So I don't think that they're going to be putting it up on the screen, because I think that everyone that needs to have a copy of it is going to have a copy of it. So the witness will have it, prosecution will have it, defense obviously has it, the judge will have it. So there are copies for everybody there that need it. And so the jury, there's no jury there to show it to. So I don't think it's going to be shown on the screen, but even if it is, I doubt that the media is going to be showing these photos. However, as Draco Amy has brilliantly put into the chat, thank you to one of my awesome mods. Trigger warning, you may need to step away for a while, mute, or catch the next stream. Look after yourself. always, we're probably going to get into some gruesome testimony here. So if that is triggering for you, take care of your mental health, please. For sure. Always most important.
First, can you describe whether or not you recognize what's depicted in that photograph? Have you seen that photograph before?
Yes, I have.
Is that part of what you reviewed in coming to your opinions and conclusions?
Yes.
What is that a photograph of?
So this is a photograph of the decedent's arm near the elbow. And do you want me to describe what it shows?
Just briefly, an
Okay.
overview of what.
Yeah, and it shows wounds.
Okay. Your Honor, I would ask that be marked as next in order of evidence.
All right, so for this voir dire, we'll have separate evidence, right? Is this an exhibit number in the trial
It
already?
has not been marked yet, so I'm fine with starting over, sort of for the purposes of the voir dire process, Howard.
So this will be a separate voir dire with separate exhibit, yes,
So it's going to be exhibit 1?
yes.
Your Honor, I want to move this along. This has been marked, but I think.
Hold on. Okay.
I'm so sorry. This one of the three has already been marked, but if, just for consistency, I'd rather mark it additionally for voir dire. Yes.
Need a separate record for the
Yeah.
voir dire.
May I approach?
Yes.
In other words, it's going to be two different evidence lists. This is what they're doing is they're not admitting these photos into evidence for the trial proper. This is just for the purposes of this hearing.
And if you'd tell me the exhibit numbers that they are.
Now, here's another thought that I'm having. If this is a risk that the prosecution is also taking by having this entire voir dire happen on camera in front of everyone, even though it's outside the presence of the jury, even if this ends up getting excluded, all of this information and this opinion and everything are going to be put out there to the public in the media, social media. Obviously, I'm live streaming this. A bunch of other channels are live streaming this. So this is something that is now going to be out there in the public. So even if it doesn't end up getting put into the trial, the prosecution also is under a lot of scrutiny because of this case, because of this trial, because of the information that's been coming out. You've even had the governor of Massachusetts commented on Trooper Michael Proctor and the things that he said in text messages. And so, there's a lot of attention being paid to this particular case and what it means for the police and all that kind of stuff. This information getting out in this hearing, regardless of whether or not it is in evidence eventually, whether or not she can testify as an expert eventually, this is still going to be in public knowledge now. So this, either way, arguably would add to the overall public discourse about this case. And the prosecution is also going to still have to contend with that. So, it's a bit of a risk because they still are going to have to, respond to all of the criticism in this particular case. So, I don't know, if one way or another, the prosecution is dealing with a number of issues here with this hearing even happening, even though this is what they wanted.
So you're putting these in now? There's no objection, Mr. Lally?
For purposes of this, no.
Okay. So we'll mark these now, but
May I approach?
yes.
The one with the label 2858 on the bottom has previously been marked in the trial. I would ask that this be marked as the next in order for the voir dire.
But what I want is the exhibit number at the trial.
Oh, I'll get that for you.
Okay, we're gonna fast forward to this part because we can.
May I, do you recognize those?
Yes.
Did you also review those in terms of, in furtherance of coming to your opinions and conclusions?
Yes.
Do they also appear to be different photographs of John O'Keefe's arm?
Yes.
I would move for the admission of both of those, Your Honor, for purposes of voir dire.
There's been no objection to them, so they're in. They're already marked.
I just need to know which one's 2 and which one's 3. May I approach?
Yes.
Thank you. Okay, that's. With court permission, may I publish
Yes.
Exhibit 2 for voir dire?
Yes.
Oh, so they are going to be showing things on the screen. Okay. Well,
Is this a photograph of
glad I gave that trigger warning.
of John O'Keefe's arm?
Yes,
Is this one of the several photographs that you reviewed in coming to your opinions and conclusions?
yes.
I want to ask you a couple of questions about this. There should be a laser pointer on the desk.
Okay.
Can you explain for the jurors what it is about the injuries that assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So for instance, let's look here, right near the elbow, the exterior part of the elbow. There's these 2 linear marks, which appear to be from upper teeth, and 2 punctures below those, which are superficial, meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern. There's another pattern close to the shoulder, which shows parallel marks, these 2, and maybe a third one in the middle, parallel marks that are oriented at a certain angle. And these are superficial wounds, which are consistent with teeth marks. They also could be possibly consistent with nail marks, but
With what?
nails from
Claws.
claw, yes.
All right.
We have some more here, similar from obviously different teeth involved or different claws, and then down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch. It appears that there's an arch pattern here. So,
In a dog attack or in an animal attack, in your experience, and we can take this one down. Let's cover the ground on the 3 exhibits that we've already marked. Can we take a look at exhibit 1? Is this just may I publish, Your Honor? Yes. I apologize. Is this just a close-up of the same injuries?
yes,
And do these appear to be consistent with what you just testified to in terms of either teeth or claw marks, especially as it relates to the area closest to the elbow?
yes,
All right. And then looking at exhibit 3. May I publish?
Yes.
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word striations?
yes,
All right, and these appear to be taken, attended to the autopsy as opposed to the other photograph, exhibit 2, that was taken in the hospital. Is that right?
that is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could,
Photograph of the wound, I guess?
it could, or different technique, yes.
Okay. Let me take these down. Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, so of course I considered, what else could have caused these wounds, before coming to my conclusion. And so I wanted to rule out other things, and there were no significant major bodily injuries outside the head. There was nothing, there were no fractures of the long bones, the chest, the pelvis, the arms. So yeah, so having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay. And in terms
I'm
of,
going to say, regardless of how you view this case, which side you tend to believe, regardless, I think that the O'Keefe family is showing a lot of strength in sitting through this hearing, and particularly through this kind of testimony where they're going in detail over the injuries that may or may not have killed him, regardless of which side you believe. But it's like, either way, this is like going in gruesome detail over these injuries. That's going to be so, so hard to sit and listen to with a loved one.
of the injuries that you did see, especially as they're attendant to the arm, based on everything that we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you. That's all I have.
Okay.
All right, Mr. Lally.
Good morning, ma'am.
Good morning.
I can take you back to, you were talking about some police training that you had received when you were in the academy or while you were working with the police department here in Massachusetts. Is that right?
Yes.
Okay. What kind of training or what did that training consist of?
Well, I attended and graduated from the Standard Police Academy at that time. And then I took additional courses that were offered from the Massachusetts Criminal Justice Training Council. And these were taught generally by experts in their fields. And they were on a variety of subjects that are listed in my CV, including, the hit and run accident investigation, forensic.
There, just for a minute, ma'am. Doctor, in reference to your training as it pertains to hit and run accidents, what did that training consist of?
Oh, well, mechanisms of how accidents occur, mechanisms of how to determine, what vehicle was involved in an accident. There, I don't, it was a long, long time ago, but yeah. So determining if people were struck by vehicles, what vehicle was involved, or if there was auto versus auto accident, what vehicles were involved.
And I don't mean to belittle this training whatsoever, but is it fair to say that that was relatively rudimentary training that you received in the academy?
Probably. I would not, yes, okay, probably. If
You don't have any training in crash reconstruction or anything like that, correct?
That is correct.
And am I correct in you indicated that you're board certified in emergency medicine, is that right?
That's correct.
And so you're not board certified in forensic pathology or anatomical pathology or any kind of pathology?
That's correct.
And the last time that you worked as a coroner, when was that?
Last time was in 1995 when I was doing autopsies for the coroner's office. I have since, though, consulted on some cases from the LA coroner's office.
What about 30 years ago?
So this question about is she board certified in forensic or anatomical pathology? It's helpful for her to be board certified in these things, but she doesn't have to be board certified in them to be able to testify about them. In Deputy Heard, for example, Dr. Curry was not board certified as a psychologist, but what's her face? The other one that was there for Amber Heard's side. She, in fact, was, but in my opinion, she was just a terrible, terrible witness. But it's not required. It's helpful, but it's not required. So, but he's also, Lally is appropriately going through where these outer limits are for her expertise and her experience and her certifications and things like that.
Joe, is that about right?
For autopsy, yes.
Now, have you ever testified in a case in which either Mr. Jackson or Attorney Little were counsel?
Not that I'm aware of, no.
And when was it that you first were contacted in reference to this case?
The first contact was May 15th.
May 15th of what year?
May 17th, excuse me, of this year, 2024. Yes.
And you went through a list of things that you were provided and you reviewed, and you mentioned hospital photos, correct?
Yes.
Autopsy photos, is that correct?
Yes.
Really quick, let me get this question here. Sonia D, isn't that all the training Lally's deconstructionist had? Did he just unknowingly insult his own witness? I mean, kind of, right? Like who has forgotten yesterday's testimony at this point? But the jury is not here to hear this right now. But if he asks the same question in front of the jury, they may look at him and be like, "What about your witnesses, dude?" So it's there's a double-edged sword in asking any kind of these questions or pointing out these weaknesses, if you perceive them as such, of this particular witness.
An autopsy report, is that correct?
Yes.
Grand jury testimony from the medical examiner, is that correct?
Yes.
A neuropathology report, is that correct?
Yes.
A toxicology report, is that correct?
Yes.
And then I think you also remembered some photos of some clothing items, is that correct as well?
Yes, a shirt. And
Anything else?
yeah, hospital ER record.
Hospital ER records?
Yeah. Yes.
Anything else that you can think of?
No.
Did you ask for anything else to review?
No.
I want to know if there's anything
Told of
Lally's
any other
thinking of.
material that was
particularly.
available for your review then that you weren't then given?
Well, I requested that that I focus in on the wounds, so I didn't ask for a lot of material in this case.
But fair to say that you were looking for anything and everything, material to the wounds that you were asked to look at, correct?
Please say that again.
Sure. Fair to say that you would want to look at anything and everything that was related to the wounds that you were asked to look at, correct?
Yes.
I'm going to laugh so hard if he's like, did you ask, or did you get the report from the accident reconstructionist that testified for the Commonwealth? I will laugh so hard if he asks about that, because that guy didn't review anyone else's stuff, even though he totally could have and should have. And that was revealed in embarrassing detail yesterday.
So did you make any specific requests as to what material you were provided, or were you just handed some material or forwarded some material and you looked at what you were given?
No, I requested that I have the autopsy photographs, the ER records, the ER photographs. I requested those.
Now, you mentioned some articles that you had written that were published back in 1996 and 1997 related to dog bites. Is that right?
Yes.
Are those publicly available articles?
Yes.
Lally, that's the whole point of writing an article, is so that people in the public can read it.
And in those articles that you wrote, you were talking about law enforcement bites, correct?
Yes.
So law enforcement canine bites typically involve what people call sort of a bite and hold technique. Is that correct?
Yes. Yes.
So is there a difference between, through your experience and the hundreds of dog bites that you've seen, is there a difference between what you would observe from a dog bite from a law enforcement canine versus just your domesticated dog?
Well, yes. Now, the study, one of those studies was over 700 dog bite wounds, and there were two techniques used at that time: bite and hold, and later on, bark and hold, or bark and alert, or something of that nature. So there are different techniques, but yes, to specifically answer that question, which was, are they generally different from regular domestic dog bites? Yes.
Now, did you write a report in regard to your opinion that you testified to here today?
No.
Why not?
I don't think there was much time, and I didn't know if I was going to be actually testifying.
How long would it take you to write a report?
I wasn't asked to write a report, excuse me.
Were you asked specifically not to write a report?
No.
Now, at any point in time, did you ever look at anything related to Mr. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. We were discussing a different case, a case that I autopsied in 1995. And I mentioned that I heard that there was a case in Massachusetts that might have been being handled by one of his colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case.
Really interesting. Really interesting. So that also speaks to whether or not there was a discovery violation here. So she basically says, look, I happen to be talking with a former DA about a case that we had, been on together, I guess, a long time ago or collaborated on a long time ago. And then the topic came up of another former colleague of my former colleague. She's talking about Alan Jackson because he used to work for the LA County DA's office. And also keep in mind, she's, the bulk of her experience is in Southern California. She has consulted for the LA County Coroner's Office. So it made sense to me that was somehow the connection was somehow there was a connection to Alan Jackson. Either he knew about her or she knew about him or something like that. Somehow they connected. So this is not. So Sable Marquette, I actually disagree. I don't think this is bad for Jackson. I think that this is similar to, if you followed the Depp trial, this is similar to TMZ guy and the other like glamping manager guy that reached out halfway through the trial to say, I actually have information that pertains to this case. And I think that I can testify. And they were allowed to testify, even though they weren't on the initial witness list because of the fact that no one knew who they were. Those other people reached out and said, I think I have information that would be helpful to you. Now, the prosecution can definitely try to take this and try to spin it to say, well, you have an interest in this case. You had already concluded or something along those lines. But, the defense can also turn to that and say, look, we are paying you as an expert. However, you had already, formulated an opinion before or you had an interest in looking into this case before even getting paid for it. Right. So it also has a possibility of diminishing the whole hired gun factor of her being an expert witness. So that's really, really fascinating. That little twist in the backstory here. Just because, thanks so much for the super chat. I really wanted her to respond, the head injury is not caused by a dog bite. I know that would have been very, very helpful, right? Jerry Roth, Legalbytes, wouldn't DA be Lally's office? So the DA is Lally's office in Massachusetts, but she's talking about a former colleague that she had worked with on a previous case, whatever. They were talking about a really, really old case from the 90s from the LA County DA. So she had collaborated, she had testified as an expert, I suppose, on cases for the LA County DA. And so I guess she had never worked with Jackson himself, but she worked with his colleagues. I actually wonder if Emily D. Baker knows about her, because she also worked in the LA County DA at the same time that Alan Jackson did, excuse me. So I kind of want to ask her if she is familiar with this witness at all. Maybe not, who knows? But that doesn't necessarily mean that she knew Jackson. That's the professional connection here, is that other colleague that she was talking to. So that's very, very interesting.
To clarify.
And so when you were provided this material, what is it that you were specifically asked to do?
To look at the wounds and the reports and the materials that were sent to me and render an opinion.
And so before you had even been provided any material, before you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So what Lally really would love to hear from her is, yeah, I made a conclusion before looking at anything, but I don't think that she's going to be testifying to that. I think that what she just said here is, I heard there was a controversy, and she was kind of like, it sounds like she was intellectually intrigued by the controversy, kind of like everybody else who has tuned into this case, right? There's a very interesting controversy that is at play here in this trial, and that is what has captured the attention of so many people. And so it seems like the same thing happened with her here, that she was like, this is interesting. This is also in my area of expertise. I kind of want to talk to people and see if I can get more information, and maybe I can offer my experience and my my expertise.
Ma'am, what I'm really trying to get at, Doctor, is sort of the timeline. Okay, so you hear about this. When was that?
Sometime just before May 17th.
So sometime just prior to that, you hear about some controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the LA District Attorney's Office.
And then who did you talk to after that?
I reached out to him. I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
And not asking specifically anything you spoke about, but at some point, the discussion came specifically to dog bites, correct?
He sent me the materials. He asked me my opinion.
Mentioned the materials, asked you your opinion. When did you provide that opinion?
Probably the next day. Yes, I know it was the next day.
So the very next day, on May 18th, you provided an opinion?
Yes,
And was that opinion provided in a written fashion, orally? How was that provided?
orally.
So you reached out to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material, and then had an opinion by May 18th.
Yes.
What he's trying to get at is that's way too fast to be able to render an opinion. However, given the fact that she has literally written reference books for everybody else in the country to use in order to determine bite marks and things like that, and based on her expertise, I can envision her spending 24 hours with all of these materials and then being like, yeah, this is what this looks like. I can totally identify this, and I can totally recognize this, and I can rule this other thing out. So, but he's trying to be incredulous, and he's, sure, okay, play it up. This is his role here. He's got to be a zealous advocate, but I can totally see her, legitimately coming to a proper conclusion based on her experience.
But you didn't write any of that down?
No.
Also,
now, beyond the
16
materials
hours,
that you were provided, what else were you told about the case?
I was told that the victim was a police officer. The decedent is a police officer. I was told that the defendant had been charged, and I was told that that there was a controversy about whether or not these injuries had been caused by motor vehicle. And I was also told, and I read in the medical record, that the decedent was found outdoors, I believe in the snow and
Bingo.
hypothermic.
Now,
Bingo. We got snow. We got snow in the testimony. She managed to get it in before Lally had to ask her.
in regard to what you reviewed, you didn't review any investigative reports, is that correct?
That is correct.
You didn't review any witness statements, is that correct?
That's correct.
You didn't review any lab reports as far as from the forensic lab or anything like that?
I reviewed the toxicology report.
Beyond that, any other?
If it was part of the autopsy report, I reviewed it.
So you reviewed everything attendant to the medical examiner's file, is that correct?
Yes.
But nothing from the lab beyond that?
I don't believe I did.
Now, this first instance, when you say you heard about it, how did you hear about it?
Well, I believe it was via a headline that I received in my email from the from Boston Globe headline. You know, it was some kind of a, you know, there was some kind of interesting case, and I got it as an email, and I looked into it.
And when
And this is something that's always very interesting with these high profile cases. This kind of a crazy thing can happen. Like I already talked about, it happened in the Deputy Heard case. It can happen in any case that is high profile in nature, where there are, you know, media reports, there's social media, people talking about it. The stuff that gets talked about outside of the trial can end up impacting the trial in ways not quite that these kind of high profile cases get criticized for. Oftentimes when people are talking about the impact of the media or social media on these trials, usually when people bring that up, what they're getting at is, well, because of the fact that there's all these social media channels that are live streaming this and commenting on it and what have you, that therefore somehow the jury is impacted by it. No, that's not what we're talking about, because the jury is not supposed to be watching anything on social media or by the media. These kinds of articles, you know, about these sort of trials have been around forever. I've already talked about how that's the entire basis of the Broadway show Chicago, right? Which of course was turned into a movie. Is like, you know, give him the old razzle dazzle. It's all about criminal trials and the obsession that the public had with criminal trials back in the 1930s or 40s or what have you, during like Prohibition era, I guess. Like that kind of stuff was a big deal. It was a big source of entertainment. So that long predates any kind of modern technology for broadcasting, of course. So the ways in which it impacts these kinds of trials is when information becomes more accessible to both sides that otherwise could have been a total barrier, because people just don't know about, the connection that they may have with a particular case. So this is where this stuff gets really, really interesting when one side or the other side, ideally it's smart if both sides are actually keeping a finger on the pulse of social media and of the media and stuff, and what people are talking about and what is getting brought up in terms of what people see and what people are commenting on. It is very, very wise when these legal teams are paying attention to what's being said about these trials, because they can get more information that can help to inform their strategy, sometimes in real time. Obviously, sometimes it can end up causing, just a distraction and things like that. But like, if they can have someone that's like in the back at the firm that is watching some streams, watching the media's reporting on this kind of stuff, and then can help to inform, like, hey, this is what people are picking up on, maybe change this or change that, or there's something like this where someone says, I actually have information that would be helpful, maybe I should get in touch with them and see if I can help. So this is so fascinating to me, is when things like this happen, that is a total curveball, and it's just because of the fact that it's a high profile case and there's just more information out there about it.
Well, that was that week in May, that, just a few days before May 17th.
You subscribe to the Boston Globe online?
I did at that time. I have not renewed it.
How long had you been a subscriber to the Boston Globe?
I'm going to allow it.
Probably a year or 6 months, 6 months to a year.
There was never any headlines or anything else that you saw about this prior to that week just before May 17th?
Not that I paid attention to.
I have nothing further.
Anything further, Mr. Jackson?
Nothing further.
All right, so since this is a voir dire, I get to ask questions, Doctor? So
Oh, yes.
I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion?
Yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very reasonable, very sure to what's the word I want? Medical certainty, very
All right, so
high degree of medical certainty.
reasonable degree of medical certainty.
Yes, definitely.
Okay, and another question. So I received information that you also viewed all reports associated with Chloe, a dog's prior bite history. Did you review those?
No, I don't recall ever seeing anything like that.
That you also reviewed the UC Davis DNA testing results submission forms?
No, I don't recall seeing them.
Okay, any follow-up, any questions based on my questions?
Not for the Commonwealth, no.
No, Your Honor.
Great, you are all set, doctor. I don't know yet whether you'll be testifying.
Okay.
Okay, well, we'll try and let you know. Are you going to be around for a few days?
No.
Okay, we'll let you know as soon as we can, okay?
Okay. Okay.
Thank
All right. Thank you.
Very interesting. Okay, so we're going to fast forward here while she gets off the stand. Now it's going to be Dr. Wolfe going to be called up to testify.
On this witness before.
Whoops.
So I would like to hear argument on this witness before we hear the other witnesses.
Before they do arguments, let's get some questions here just to make sure that we're all caught up and up to speed on everything there. Travis James, question, did Bev just say the other two witnesses are okay? She didn't conclude that she's going to allow them to testify, but it does sound like there is less of an issue with the timing on that because it's like very clear to her, or at least it's very clear, generally speaking, I guess, maybe not specifically to her, the timing on when they became apparent. In my opinion, I still don't think that Dr. Marie Russell, was a discovery violation, especially based on how she testified about how she came in contact with them. But that's just me. Travis James, question, did Bev, sorry. Wait, I literally just read that. Dianisa Duclos, she was looking at a ghost jury. No, she was, that's the media that's there. I definitely talked about that before, but I think I had saved this before then. Sorry, let me just make sure that I am capturing these newer questions that are coming in. Did I miss anything here? I think, okay, here we go. Okay, I hope I haven't missed anything. I think I captured everything. Sharply opinionated, will she repeat all this to the jury? And question 2 is Lally shaking his head, wondering how to refute the witness. I mean, he definitely probably is trying to figure out, how to minimize her testimony, how to exclude her testimony, if at all possible. I am not sure. But so her experience absolutely would be repeated. If she does testify, her experience, she will be testifying in front of the jury, because even though the whole voir dire process is outside the presence of the jury, she's still, they still are going to want to get into her experience to show the jury why they can trust her, what she's saying. So that is, that's a big reason why. And every other witness who has testified in this case has testified to their experiences, especially those expert witnesses for the prosecution. Sonia SS, question, did we have the Lally tally from yesterday? I'm not sure if I missed it. No, you did not miss it. I totally intended to talk about it, and I forgot. I think I forgot. Okay, so after day 25, the Lally tally was at 1807. Day 26, there were 97 what if any's. So that means that the grand total going into day 27, going into today, is 1904, 1,904. So we are just about to hit 2,000. Will we do it today? I don't know. If not today, I think tomorrow there's a good chance, because we've got the medical examiners coming up. So there's plenty of what if any opportunity to be had. Okay. I don't know. Should we make a t-shirt if we hit 2,000? I survived 2,000 what if any's. Okay. Daniel Evans, question, can she be the official Legalbytes grandma? I love it. Sable Marquette, question, Can prosecution object to any of this? They can object. Is basically the purpose of that is getting something on the record, not necessarily to exclude, because most likely the judge is going to want to hear more information, not less information. We're not worried about a jury hearing something that they shouldn't be hearing. So that is not so much of an issue, but there is a purpose in objecting, and it's to get something down on the record. Tish, Legalbytes, is this a late disclosure witness? Didn't they have this witness before the start of the trial? So this question came in before the witness testified about how she reached out to them on like just before May 17th. She managed to contact them on May 17th. She gave an opinion on May 18th based on the materials that they gave her. So no, trial had already begun in late April. Like, trial was already started when she contacted or tried to get in contact with them to give them her information so that she could look into this case and see if she could render an opinion for them. So, if they didn't know of her existence before this point, then that's not a discovery violation, in my opinion. So I think that if Judge Cannone continues to hold on to that opinion for that, and that's ultimately what she does rule here after this testimony, I think that's totally incorrect. I very much disagree with that decision here. Buttercup 203. I want to ask her if she had Chloe, could she determine wounds are for real her? I'm sure she could, because all you need to do is measure her teeth and her nails. Sybil Marquette question: do you think this will force prosecution to bring out the ME to try to rebut / get in front of this witness, assuming she is let in? Well, I think that they might emphasize more of certain parts of the testimony of the medical examiner in order to try to get ahead of it. However, they cannot ask the medical examiner to render other opinions that are not already in the report. That was the problem that they got into with Trooper Joseph Paul, because they tried to have him watch the video, the ring footage video from 5 a.m. on January 29th in front of John O'Keefe's house, and to have him give an opinion as to whether or not he thinks that could have cracked Karen Reed's taillight or broken Karen Reed's taillight. So they tried to do that. That wasn't in his original report. That ended up being kept out. So they are limited by what kinds of opinions she or he rendered in the expert report that was handed over to the defense. Honest Mike, what if Indy is actually Chloe? Can you prove when Indy came to live with you? This goes all the way to the top. I know, man. Well, I can tell you. So this all happened in January 2021. Timing wise, we did adopt her in early February 2021. So like literally like the first week of, so like literally within a week of this all happening, but on an opposite part of the globe. And also she was 4 months old and just a tiny little puppy. So maybe I will be posting to Instagram and Twitter later a photo of what Indy looked like, so that we can exonerate her, and you can tell that her jaw was way too small, way too small to be the attack dog in question. We need to exonerate her. The Lucian, legal-wise, the thing is, if the prosecution didn't try to reject this, then the witness would still have testified. So this was happening regardless. Best case prosecution got reject outright. That's fair. That's fair. They're kind of between a rock and a hard place with this. So that makes sense. Also, I don't think I read this one earlier. Thank you so much for the super chat, Phantom Split. Just want to say I appreciate your willingness to call what is good and bad for both sides, and that you pause testimony for your insightful opinions. Love the channel. Thank you so much. Thank you. When I started to pause instead of just letting the testimony roll and just commenting over it before, that's what used to be kind of the norm. Before I started doing that, there were complaints from people that they were like, I still want to hear the testimony and you guys are talking over it. So I started pausing to give commentary, and I wasn't sure if people would be okay with the fact that then delays the liveness of the experience. But it seems like that's been the right call so far, because I think a lot of people want to hear the testimony. They want to hear the proceedings. They want to hear all the stuff going on in the courtroom, and they want to hear the commentary. So, lengthening it, I don't mind it. So if you guys don't, then that's good. Spunky Nuggets. Legalbytes, can defense ask more / different questions during direct examination if Dr. Russell is allowed to testify? I think they can probably, yeah, they can flesh out more. The issue here was that Judge Cannone was saying that she wasn't going to limit the kinds of questions that the prosecution can ask. So that's the difference here. Essentially, if she does allow this in, the prosecution can't then come back and say, well, we didn't have an opportunity to go through this or go through that, and therefore we're hamstrung. Therefore, this is unfair. If she had this open-ended thing to say, ask her anything, then it's kind of their own fault if there's something that they didn't ask her when they had the opportunity. So that may be her thinking on that. Baz 80s. Question, in your opinion, is this a good approximation of what we can expect from the defense case in chief? I think this is a pretty good little preview of it. Probably not in its entirety, because they don't want to give their entire direct examination away. But this was a good little snippet that is probably very, very revealing for what we're going to see here. The Lucian question regarding what material Russell saw / requested Lally didn't seem to spring anything. Could he be holding it for the jury for when the jury is there? Is that a loud and or slimy strategy? No, I think that there's still more detail that he can go into appropriately later on in front of the jury, and it's fine. It's all fair and love and war to a certain extent on cross-examination, especially because Jackson is likely to flesh out a lot more in the direct examination as well. So cross-examination has to be able to respond to direct examination also. So I think that there's a good likelihood that he can go into more as well on cross. Tish, Legalbytes, isn't it weird that she was contacted this late? Did they possibly have a different expert that they wanted to call? No, I mean, as she testified, she said that she actually contacted them, which was very, very interesting to hear. Jonathan Willig, update. Oh wait, well, one more second. Let me capture this question here. Update, lawyer for Brian Walsh is filing a motion questioning conduct in Walsh's conviction for murder. The possible questionable conduct names Trooper Michael Proctor. I expect that to be probably not the only one. I'm sure there'll be others as well where people are going to be filing similar stuff. There could be an entire cascade of cases that get, at the very least, looked at, if not overturned, because of Trooper Proctor's involvement. Baz 80's question, is he really questioning an expert who took a day to make her mind up after seeing evidence for Proctor can know who did what in 16 hours with not seeing any evidence? I know, it's pretty ridiculous, right? That's why if he asked that question in front of the jury, I don't think that's going to go over so well. I think he's going to end up setting himself up for an embarrassment if he does that. El Borate, has YouTube demonetized any day's video for content? Yes, multiple days, and it's all because of, ironically, they've limited monetization rather than completely demonetized. But the days that are very spicy, like the Trooper Proctor days, those are limited. I tried to ask for additional review, but they had a human look at it and they were like, no, this is still a little too spicy for our full monetization. So unfortunately, it is what it is. That's just what happens in these trials. Sometimes you can't necessarily control for everything. I can control what I say, and that kind of limits some of these issues, but trial is trial. The facts are going to come in, and when the facts include that somebody said something that is particularly horrific, it's going to play out on the screen and in audio. John Marshall, what do you mean you don't know if she'll be testifying? So Judge Cannone said, I don't know if you'll be testifying. That means that she hasn't made up her mind yet on that. She's going to take a minute to decide that. Blue Tuna Tiger, one question, why didn't he ask her about the absence of dog DNA? Because she didn't look at those materials. That's what it turned out. I think that's what we heard about towards the end. Debbie Faison Cook, the Lucian. I don't know what the basis is. Oh, sorry. I don't know. Oh, I guess I got tagged for that. Okay, but I didn't see the initial question. Let me get some more here. Okay. Yep. Got him. Jerry Roth, did someone feed the judge false info on the first witness? I don't know. This may have been her understanding based on the back and forth that happened beforehand. And maybe she just got confused based on what she heard. I don't know. M. DeLorean, question: can the prosecution switch stories and say that a random dog bit O'Keefe after he was already lying in the snow being struck by the car? They can, but if they do that, that is 100% them moving the goalposts. And the jury is going to see right through that. And on closing, the defense will totally use that, run laps with it, use it as a flag for them to be like, now the prosecution's narrative is changing based on the evidence that actually came in. And that is 100% their right to do that. Dan Luch, question: what about the last questions asked by the judge? She's allowed to do that. She's allowed to also ask her questions because of the fact that this is not in the presence of the jury. And ultimately, the judge is the one who's going to be making this decision. So if there's particular information that she wants to keep in mind or consider, then that's she's allowed to do that. Daniel Evans, question: do you think Lally's cross is as bad as his direct? Well, he can lead, and he's supposed to lead. So there's fewer what if any. So at least there's that. We'll see what a full cross examination looks like, though. It wasn't as bad as his direct examinations, so I'm hoping that his cross is better. It's easier to follow, because then it'll just move so much smoother. El Borate, it seems an expert reading others' reports get confirmation bias, and if they don't, they know everything. What's right? No. I think that when we have an expert, the whole purpose of them being an expert is we trust that they can think independently about a particular case. And it's not just rank speculation or them, lining up their testimony. They can comment on how their opinion is different from another expert's, or how it's the same, how it's better, or how the other guy's is worse. So that is, it's always better for the expert witness to have more information that they use to look at, because then it's a more thorough analysis. The Rubber Duck 77. And actually, sorry, let me go back to that to fully answer. It's the cases where an expert witness doesn't look at as much information that it seems like they are looking at information just to satisfy that confirmation bias. So that was like the Trooper Joseph Paul. He didn't look at much of any other information at all. It looked like he looked at certain pieces. He had a bias. He confirmed it by looking at certain pieces of evidence, but he didn't look at everything. And so therefore it was a less thorough analysis, and therefore confirmation bias was present there. The Rubber Duck 77, can the jury ask any questions during trial or at the end? Not in this particular case. At least, I don't know if that's the case in Massachusetts in general, but I think that I know that in this case, that's not a factor here. I know in some cases that have been televised that has been, but not here. The Lucian question was, judge indicated she had reports that Russell saw dog DNA expert report and dog bite reports of Chloe. I was wondering what information did the judge think she had? Oh yeah, I'm not sure exactly where she got that from. But it does seem, I don't know, from her testimony, and maybe there was a miscommunication by the defense. I don't know. El Borate. So are all police experts? If not, who is? No. Police officers typically are not experts. They still have to be qualified in the same way that any other expert witness has to be qualified. The fact that somebody is a police officer does not automatically render them an expert, because, especially the ones that just responded to the scene, they testify to what they saw, what they heard, what they felt, what they smelled, that kind of stuff, the five senses. So they are still lay witnesses. It's the ones that do a particular kind of analysis that will potentially be expert witnesses. Doesn't necessarily mean still that they are expert witnesses if they are the ones that are, for example, just like gathering the information for someone else to do an analysis. And the Rubber Duck, if not all police are experts, you need to tell that to the CW. I know, right? And before we get going, one more super chat here. Chris Martin, thank you so much for this super chat. Very generous of you. Trooper Paul said O'Keefe's arm was bent upward when it hit the tail light and caused him to spin. Wouldn't that have caused the scratches to be on the outside of the arm instead of the inside of the arm where they are? Also true. Also true. And one more question here. Jerry Roth kind of makes Trooper Paul look like a guy who took 125 hours of a course as opposed to years of experience that Dr. Russell has. Agreed. Agreed. All right, let's get back to the voir dire, and we're going to hear the argument from the two sides. So let me see here. 1 second. Okay, let's do it.
So, and Ms. Giannetti, I asked you the other day whether she reached out to you or you reached out to her, and you said there was an intermediary. But my concern was whether she came out of nowhere and reached out about this case. And that seems to sort of...
It wasn't Mr. Giannetti, it was me.
Okay. All right. So the question I asked was answered pretty much by this witness, whether she saw something and decided she wanted to come forward. All right, it's the Commonwealth's motion. What are you asking me to do? Again, I found a violation of Rule 14.
I think that's wrong.
And there are two concerns here, the competency of the witness's testimony, how much she can testify to, whether she should testify at all. What is it you're asking me, Mr. Lally?
Your Honor, I'm asking that the witness be excluded from testifying at the trial for the violation of Rule 14. Specifically, I believe it's Rule 14A6. This is a witness, as the court picked up on, that reached out, albeit through an intermediary, with reference to just sort of discovering or coming upon this case in several weeks into the trial. It is concerning given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point. The limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also,
Sorry, I'll let it.
I would note for the court, includes photographs of what a dog bite from that specific dog looks like.
Okay, so him saying that, like, the fact that she didn't review the UC Davis testimony or reports or what have you, that being a big problem, is to me incredibly laughable because of everything that we just saw yesterday with Trooper Paul not reviewing basically like anything else from anybody else. Like, that is also something that can be remedied with cross-examination by asking her in front of the jury, you didn't review this, you didn't review that. So that can be a limitation that you point out to the jury.
And that specifically apparently was not provided to this witness, who's then opining on, inferably at least, that that dog was the cause of these particular injuries. However, was not shown specifically anything to do with that bite history as far as by way of reports or photographs. So that juxtaposed or coupled with the immensely late disclosure. I mean, we're talking about at least the 6th week of trial by the time this witness is even mentioned, not on the defendant's witness list, not mentioned at any point in time during the pendency of the case, and then sort of pops up in the middle of May, and to the point that the limited amount of material or information that's provided by counsel as far as disclosure opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
No, I think the fact that she hasn't reviewed anything for like related to specifically Chloe, yes, that's a weakness in her testimony then, if that's the case. However, that can be remedied with cross-examination. You can point that out in front of the jury. You can tell them like, hey, look, this is a glaring weakness in this whole like causation part of their theory that they can't say definitively that this is Chloe who did this, because, bite marks could have happened with another dog or something like that. They can point that out essentially on cross-examination and try to limit the scope of her opinion that she can, reliably give, that the jury can actually rely on. So, to me, that's not a reason to exclude. That's a good way to cross-examine her.
Jackson?
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't do anything wrong. As the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
What I was trying to get at, is this somebody who read about this case and said, I want to be part of that? That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
okay, I did not misrepresent anything to the court.
I didn't say that.
I take offense at the court's tone that yes, you did say that. You just said that.
Uh-oh.
You said,
Okay.
I just heard the testimony. And
See, normally I really love Jackson's spice, but having that spice with the judge, especially when she's about to make a determination, on a particular motion that is important to you, I want him to be careful. Here, I would prefer for him to be careful.
it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County.
So maybe it wasn't clear what I was looking for. I think it was clear. But go ahead,
Okay.
continue with your argument on this.
Okay, so the judge is actually being pretty chill about that, kind of backing off to say maybe I misunderstood, maybe I wasn't as clear as to what I was looking for. Okay. Like, I'm a little bit less nervous now about how this is going to proceed, because it seemed like this was a situation that could have escalated.
Yes.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong.
Yeah,
In other
I
words,
agree.
It connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced, and I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information, we then had a discussion amongst ourselves. Is this somebody that we want to then present on the defense side, on the defense case? And we turned the information over to Mr. Lally. I understand that it was well into the trial, but that's not a fault of ours. And I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scortibello and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory
Yeah.
of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a taillight, including Mr. Paul yesterday. We have contrary evidence, and Ms. Reed should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours, and I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late. Obviously, Mr. Lally is a skilled lawyer. There's nothing to say that he can't or hasn't been able to prepare for the cross-examination or for an examination in front of the jury. And I just don't think exclusion is appropriate.
All right. So there's
I very much agree with what he's saying. I think that exclusion is the heaviest remedy here, and it is reserved for only the most serious cases with discovery violations, assuming that you even find a discovery violation in the first place. And I also agree this was not a discovery violation. This is someone who reached out to him. Like you can't hold lawyers responsible for the information that they didn't have. So, like I said, I've already talked about it multiple times. We've seen this in other trials before. Information comes in mid-trial because somebody heard about it because it was a high-profile trial. They should not be punished for that because of the fact that someone came in late in the game and said, I have information that might be helpful. So I 100% agree. I don't think that this is a Rule 14 violation. I don't think that this is something that should be excluded at all. Can there be limitations to like, the weight of her opinion? Sure. Based on the fact that she didn't review certain pieces of information. Sure. Okay. That's fine. But that means limiting her testimony, not excluding it entirely. Alex 025, thanks so much for the super chat. Karen Reed found a giga chat of a lawyer. I would have whimpered and said, sorry, Your Honor. This speaks to the experience that he has being in front of judges, being in some high profile trials in the past. This is someone who is not afraid of judges. So, that gamble paid off, because I think that the reason why it paid off for him to get so testy with the judge on that and like offended and all of that is because what he said he told to the judge was consistent with what he said he told to the judge. Like, there was nothing different now that he's saying now, as opposed to what he had told her on sidebar before. So I think that's why he was able to get away with it, because he probably was 100% right on that. It just, maybe her communication was a little bit wonky and there was a misunderstanding on her end. It's from what it sounds like, because based on the way that she backed off from it. Let me get some questions really quick. El Borate, Legalbytes, can the defense offer the doctor testify last to give CW time as a remedy? No, it's not going to change the overall procedure of the case. They're doing this before the medical examiners testify, and I think there's a reason for that, because of the fact that they may need to address this particular expert's testimony in their testimony themselves before they get to that. Stephen Horton, question: I have subscriptions to multiple media sources. Doesn't mean I actually read them. I also own hundreds of books I've never read. LOL. Also, yeah, agreed. There also is, sorry, that noise, by the way, is just, it's my, I love this chair. The one thing is I wish that I could like lock well, maybe I can. I don't know. This is still a new chair, but sometimes I press on the armrests and it like they shift forward. It's great that they can shift, but I'm hoping I have to figure out some way to lock these. Anyway, totally divergent train of thought. So yeah. So Lally also pointing out the fact that like she had to have known about this beforehand is a bit laughable, because you also have 15 jurors that have been selected to be narrowed down to 12 jurors who live in the area and have testified at least to a sufficient level that they don't know enough about this case to have formulated an opinion. So it's laughable that he can confidently seat a jury, and yet, that is unbiased, and yet say, no, she had to have known about this all the way on the West Coast, which is not local. Local TV channels may or may not be talking about it. It's national TV that people would be catching on the other side of the country, or social media, of course. So, like him using that as a data point is No, I don't buy it. Baz 80's question, if she is denied testifying and it's a mistrial, can she be brought in on the next trial if it were to happen? 100%. Absolutely. Also, I do think that if she is excluded and Karen Reed is ultimately convicted, I think this is reversible error. Also, what would be a good reason to deny her testimony? If you were prosecution, how would you try to exclude her? A good reason would be if the defense knew about her a long time ago, they even had talked to her, had gotten reports from her well in advance and just sat on it. That would be a good reason to exclude her, because that is someone who is gaming the system, and that's not fair. So that would be appropriate maybe in the under those circumstances, but yeah, not under these that we've found out here. Heather Miller, Legalbytes. So she doesn't really need to convince anyone that it was Chloe, though, right? Just that a dog did it and not Karen's vehicle. I mean, that's still exceedingly helpful for the defense. If they can score, a grand slam as opposed to a home run and have her tie it directly to Chloe, that's even better. But, at least for her to be able to say, hey, look, these injuries are not from a car. They're not from a taillight. These injuries are from a dog. And then the defense can say there's only one dog involved in this case. No one else is talking about any other dog other than the one dog that happened to live inside that house that he was found on the early morning hours of January 29th, 2022. Sarah J.H. Legalbytes, if Judge C wasn't always in such a hurry to move the defense along, maybe she would have been understood better. I don't know. She just always seems to be pushing along the defense. She sometimes does push along the prosecution too, but I see her point there. The Rubber Duck 77, Legalbytes. Could the remedy be 2 to 3 days break in trial to give them time for Russell to write her report and get it to the MEs? Maybe. I mean, I think the prosecution would argue that that's still not enough. Sharply opinionated. Question, why doesn't Jackson state that she is newly retired and didn't have time for newspaper subscriptions before, wanted info on her hometown? Well, I don't know. I don't know when she said that she retired. I don't know. I can't remember if she said specifically when she retired. It seemed like she has been retired for maybe a little bit of time. But I don't know. I mean, it could also be that you've been retired for a while and still don't check your overfilled inbox every single day to get certain updates on stuff. I don't know. All right, one more question here. The Rubber Duck 77, Legalbytes, is he worried about plot twists? The Emmys got their dog bite training from Russell. That would be really funny. That would actually be really funny. All right. Let's get back to the hearing.
Second part of this argument, and I'll start with the Commonwealth first. So in your motion to exclude, you also raise Daubert type concerns. So Mr. Lally, is there portions?
So she just referenced Daubert. That is one of the standards for basically verification of a witness to be established as an expert witness. So remember I said default is every witness is a lay witness. You have to go through a certain rigorous, I mean, I say rigorous, but then I think about yesterday's expert, Trooper Paul, relatively rigorous methodology basically of vetting this witness to say that we can appropriately rely on their opinions as an expert. So Daubert is one of those. It refers to a Supreme Court case that established the test for it. Some states use that. Some states use a slightly different test that's a little bit of a lower standard. Daubert is considered the more rigorous one, and that's what most states use.
If I permit her to testify, are there portions focused specifically on the part of her opinion where she says, I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. I think you have an uphill battle on that part, Mr. Jackson. Commonwealth, what are you saying? If she,
Yeah, hell yeah, you do. That's kind of a ridiculous argument at this point, don't you think? Based on all of her experience, her depth of experience, her length of experience, just like that's pretty funny for her to be that candid right now, to be like, I'm sorry, like you got an uphill battle there, sir.
She testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to test the doctor to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint, as some factual questions in regard to that. But from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work in history in that area, observing prior injuries related to animal attacks, and whatever consistency she believes that they have with that.
I'm sorry. Wait, did people interpret that she said that Jackson has the uphill battle? I'm sorry. Let me go back then and listen again, because I got that, but okay.
The scratches from these injuries are, I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. I think you have an uphill battle on that part, Mr.
Oh.
Jackson. The Commonwealth, what are you saying?
Oh, you're right. That's ridiculous. That is also ridiculous to me. Okay, I'm glad I went back to
If
check
she
that out.
if she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to test the doctor to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint, as some factual questions in regard to that. But from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work in history in that area, observing prior injuries related to animal attacks, and whatever consistency she believes that they have with that. I do not think it would be proper to allow this witness to testify or opine anything about the inconsistency with regard to pedestrian injuries.
Why? She has so much experience with vehicle collisions and all kinds of injuries related to collisions with vehicles. Like she testified about that in her history. So why? What about her experiences that she's not qualified to give that kind of an opinion? That's ridiculous.
I don't think any proper foundation has been laid for there, whether it be through experiential knowledge in relation to that, or any sort of specialized training or knowledge, or anything to do with that. Anything from a forensic pathology or anatomical pathology perspective, I think should also be out of bounds and excluded with regard to
She's not
this
board certified?
witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think is permissible. But as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence, and simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision, is just plain wrong.
I'm sorry. This is just laughable on its face, especially considering the expert that he just put on yesterday for his accident reconstructionist, who didn't use physics. He didn't use math in order to reach his conclusions. To say that like she can't, based on all of her experience as an ER doctor, as someone who is consulted for the coroner's office in Southern California, which is a car culture where cars are part of everyday life, even more than probably anywhere else in the United States. No way, no freaking way.
And not backed up by science or anything else that this witness
Not backed up by
can
science.
testify to.
Oh, that is so rich. That is so rich considering everything that came out yesterday.
From the very limited experience she has in that realm. So if the witness were able or permitted by the court to testify, I would submit that her testimony should be relegated to simply what, if any, opinions,
we
her
got a what, if
experience,
any.
obviously, and then what, if any, opinions she
Another
draws with regard to the causation of the injuries on the right arm, as it pertains to consistency there. But I venture to guess that it's likely that those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
If she's being reasonable.
All right, Mr. Jackson?
I'll submit, Your Honor. I have no issue with, I just said I'll submit, I'm not submitting. I have no issue with limiting her testimony to the animal attack issue, the dog attack issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question that's consistent with the motor vehicle incident. I have no problem if the court wants to limit her testimony to the dog bite aspect and not the motor vehicle aspect. I wasn't planning on going into that aspect anyway. I've got another pathologist who's going to do exactly that.
Okay.
But you did go through it with her, and it's on your disclosure.
It is, but I have no problem editing that.
So why is it on the disclosure, or where the Commonwealth turned over, that she viewed all reports associated with Chloe's bite history in the UC Davis DNA testing? Why is that in there?
Because we sit that in a Dropbox. We sit everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it. I didn't know. But that's what was sent to her. Everything that's in the disclosure is what was sent to her.
All right. If she's permitted to testify, you led her through quite a bit today. You won't be able to. I mean, she struggled with to what degree of certainty she held an opinion. She struggled to what she viewed. She didn't write a report. I have to consider all of these things too, as the gatekeeper, as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Not terribly long, Your Honor. As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Yes.
Why don't you start looking at least? All right, well, I decide I won't know until Thursday.
Sure.
All right.
She won't know until Thursday, but that signals so you're saying there's a chance. There's a chance she may actually let her in. And I think that one of the things that she's considering is the fact that this is a defense witness as well. There's a question here, Sarkadoodle. Legalbytes from the UK, so this confuses me a little. Are there no protections for miscarriages of justice, e.g. evidence is so bad the judge throws it out as conviction is deemed unsafe? No, I mean, judges she just mentioned, she referred to herself as a gatekeeper of the evidence here because, she has to be the one to determine whether or not this is something that's going to assist the jury. Maybe it will spoil the jury. There are all kinds of reasons why the judge is the gatekeeper of the evidence that comes into trial. And so she also has to determine, if something comes in, will it end up causing some kind of a mistrial? Because there's no way that the jury can possibly come to a conclusion that is appropriate here. Yeah. Also, some more questions here. El Borate, did you see on LTL that the prior chief of police in Canton is out front of court demonstrating also? I did not see that. That's interesting. Hawk Wind, Legalbytes, you are one of a multitude of attorneys who are questioning these approaches to this case. Could federal authorities also be paying attention? 100%. 100%. I have covered enough cases now at this point to have actually been reached out to, typically afterwards, but reached out to by someone connected to the case, whether it is some sort of a PR firm or whether it is, one of the attorneys on the team afterwards reaching out to talk about the coverage, or, that stuff happens. It's happened enough times that I basically assume at this point that people are watching this stuff. People are watching social media streams. People are watching the news, whether they are federal investigators or the legal teams on either side. It's it's kind of wild, but at the same time, it's like it's happened enough now that it doesn't surprise me. Tish, Legalbytes, what the question does the judge mean by saying she struggled to what certainty she held an opinion? So what did she mean by that? She meant that the witness was having a hard time being able to give an opinion on a particular subject that she was confident in, which, to be fair, if you watch Letterkenny, that also happened yesterday with the witness that was on the stand, Trooper Paul. So, okay, is that a reason to disqualify an expert witness? I don't know. As Jackson said earlier today, what's good for the goose is good for the gander, maybe. The Rubber Duck 77, Legalbytes, do you think Russell was struggling with certainty or just the word to use? I think that she was pretty forthright about what she could and couldn't conclude. And I think that she would be the same way on the stand. So I think, maybe what word to use? Sure. Just because the question is, Lally even going to be done with this case in chief in the next week? Supposedly, they only have 2 witnesses left. And so there's a chance that could end on Thursday or Friday. We will see. All right. Okay, let's continue on.
All right. Anything else on this witness?
Submitted, Your Honor.
Okay. All right. Next witness, please.
Dr. Wolfe.
With regard to Dr. Wolfe and Dr. Rentschler, this is a different scenario, and I'm presuming that the court is asking for a 1 year on their qualifications.
Well, I want to know who did what. They say we. I want to know who did what.
So is the court suggesting that I go through their entire testimony of exactly what they did, their testing, their opinions, conclusions, the bases of their opinions, conclusions?
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
I realize that, but it's not the Commonwealth's motion to depose our experts. The Commonwealth's motion is they're not qualified as accident reconstructionists. I don't need to go, and I'm not inclined to give them a free bite at the apple to cross-examine these witnesses twice on the basis of their opinion. I will go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified to render opinions, but I don't think it's incumbent upon me to walk through their entire testimony and give the Commonwealth a free bite at the apple like it's a deposition.
Whatever you want to do. I'm not telling you what to do. Whatever you want to do.
Would you like, please? Be mindful of the step. As your next stand, face the clerk to be sworn.
So, do you ever see the court in the case now and here and should the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right.
Proceed and just speak very loudly into the microphone.
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
Sir, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
And tell us a little bit about ARCA. If you could explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
You said that you were the current director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
what about other clientele? For instance, maybe it's an insurance carrier or a law firm, but what about the ultimate client? The military, Department of Defense? Have you contracted with other entities or agencies?
Sorry, just as a military spouse, I think it's funny. The ultimate client, the Department of Defense. I don't know. For some reason, I just found that kind of funny. That made me chuckle.
Sporting agencies.
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
Wow.
And in terms of ARCA and its commissions and consultation, is it known both nationally and internationally? Is it recognized as a leader in the area of accident reconstruction?
Yes.
As the director of accident reconstruction, do you specialize in not only accident reconstruction, but human factors as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. You know, I've been involved with pedestrian impacts, and that can be pedestrians hitting the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
He's already more qualified than Trooper Paul. I'm sorry. I almost want Jackson to be like, sir, can you tell us what physics is? And be like, I have no further questions.
When you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming out onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
And that might include everything.
Compare that to the visibility test that Trooper Paul did, where he was like, well, we didn't really need to actually mimic the factors under which Karen Reed was driving to see what she actually saw, because, you know, we kind of just assumed that this was a you know, an intentional act as opposed to an accident. So like, you know, same factors. Who cares? We're just kind of sort of going through the motions on this thing. This is very different. Also, let me get a question really quickly here because it's better to answer it earlier rather than later. This particular one from Tish. Please translate the significance of whom he has worked for. So he's had clients that are the military, U.S. military. So basically, like these are big contracts that they would have been working on for to analyze injuries, whether that is maybe with, you know, human injuries coming in contact with one another, or, you know, humans getting in contact with machinery or with weapons or things like that. You know, there's a lot of ways that accidents can happen in the military. You hear about helicopter crashes all the time, for example. I mean, maybe not all the time, but, you know, occasionally you hear about these kinds of things. And so to have someone that is on that level of accident reconstruction, it's like something as simple as a pedestrian collision, they probably can testify to. As well. It's the NHL, that's the National Hockey League, talking about, you know, two guys coming in contact with one another and the injuries that result, bruising, losing teeth, breaking bones, all kinds of things. That's a different kind. It just shows the breadth of the sort of impacts that human beings have had with various objects or with each other. That's the significance of all of these different clients that he's worked for. So there are other questions here that I'm gonna continue on with this questioning here. So we're gonna keep these. I have other questions that are saved. I'll answer them in just a second or in a little bit.
everything from passenger vehicles, commercial vehicles, bicycle issues, motorcycle issues, things of that nature.
Yes, sir.
Okay. What education, training, and background qualifies you to perform the duties that you just described as Director of Accident Reconstruction at ARCA?
In terms of my educational background, I received a Bachelor of Science in Engineering from James Madison University back in 2012, along with a minor in mathematics. Some of my coursework while at James Madison included courses in physics, statics, dynamics, kinematics, material science, and your typical engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
He's so much more qualified than the other guy. He's like 100% more qualified. It's so funny.
Did your research area also include physics, in addition to electromagnetics?
Yes, sir.
Optics?
Yes, sir.
Photonics?
Yes, sir.
And lighting?
Correct.
Are you accredited as a traffic accident reconstructionist?
Yes, sir.
By whom?
By an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry to determine vehicle crash and map scene evidence from photographs?
Yes, sir.
In other words, looking at a photograph rather than being at the scene, that is a specialty or a specific area of training that you've engaged, correct?
Yes, sir.
Are you trained in Bosch crash data retrieval analysis,
Yes, sir.
otherwise known as CDR analysis, right?
Correct.
In terms of professional associations and accreditations, are you certified by the Society of Automotive Engineers?
Yes, I'm a member of that organization.
What about being a member of Optical Society of America,
Yes, sir.
Illuminating Engineering Society,
Yes, sir.
and finally, the National Association of Professional Accident Reconstruction Specialists?
Yes, sir.
You're accredited by all of those organizations, is that right?
I'm a member of all of those. Yes, sir.
Have you authored peer-reviewed articles in the area that we've just discussed?
I've authored a number of papers in the field of physics, and one of my most recent publications was that dealing with Toyota and Lexus vehicle control history records.
In 2021, did you author or co-author a peer-reviewed article known as Collision, the International Compendium for Crash Research Dealing with Vehicle Control History and Braking Issues?
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, have you and I ever met face-to-face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Do you know who she is?
Yes.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think that's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Josh, I thank
Your
you so much for the
analysis,
super sticker.
conclusions, and opinions are
Thank you.
completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom.
Correct.
You and your team were asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court. Is that right?
That's correct.
Who at ARCA was assigned to the team who ultimately would undertake that analysis?
So it was myself, Dr. Andrew Rentschler, and Scott Klein.
And Scott Klein has a Master of Science, is that right?
I believe he's got a Bachelor of Science in Mechanical Engineering, yes.
In engineering.
Correct.
All right. And Dr. Rentschler is a PhD in what area?
Biomechanical engineering.
Were you provided and did you review certain materials in furtherance of your consultation in this matter?
Yes, sir.
I can have just a moment, Your Honor.
Yes.
I'd like to use my time efficiently, Doctor. I'm going to read through a number of materials that you reviewed. Before I do that, may I approach, Your Honor?
Yes.
I just want you to take a look at the first 2 pages of that document and tell me if you recognize that.
Yes, sir.
What is that? What are those 2 pages?
These are the first 2 pages from the report that ARCA issued in regards to this matter.
Do you see a list of 14 items on those 2 pages?
Yes, sir.
Is that an accurate reflection of the items that you were provided by this other agency to review in terms of coming to your opinions and conclusions concerning this case?
Yes, sir.
May I approach, Your Honor?
Yes.
Those items include the Norfolk SPDU homicide death report, correct?
Correct.
The Commonwealth of Massachusetts Department of State Police crime scene report, correct?
Correct.
The OCME dispatch removal report, correct?
Correct.
Photographs of the incident location.
Correct.
Videos of the incident location.
Correct.
Photographs of the 2021 Lexus LX 570.
Correct.
Photographs of recovered evidence.
Correct.
Crash data retrieval report from the 2021 Lexus 570.
Correct.
Report of autopsy.
Correct.
Autopsy photographs.
Yes.
3-dimensional laser scan data of a Lexus LX 570.
Yes.
A VIN-Link, VIN capital LINK report sheet for the 2021 Lexus LX 570.
Yes.
Expert AutoStats data sheets for a 2021 Lexus LX 570.
Yes.
And publicly available literature, including but not limited to the documents cited within the report, learned treatises, textbooks, and scientific standards, correct?
Correct.
All of those items and data were reviewed by you and your team in coming to your conclusions and opinions in this case, correct?
Yes, sir.
And I'd like to
Oh boy. He is going to testify about not just Trooper Paul, but also Trooper Guarino, about all of the data that they got and didn't get from the Lexus, the 2021 Lexus, what was available, how they could have gone about it. I'm thinking he's probably going to get into that infotainment system that Dr. Guarino testified yesterday, that he was like, well, we couldn't get it because the data got corrupted and then it got permanently corrupted. So there's no way to retrieve it now. Too bad, so sad kind of thing, because we were trying to work with Bursa to get that software, blah, blah, blah. They said they wouldn't, they didn't have it. We've been going back and forth with them for well over a year or something along those lines. So I have a feeling that this witness is also going to testify that was entirely possible for them to get the infotainment system data if they had just done it correctly, and that they didn't do it, that they didn't get it because they are incompetent fools. So I have a feeling that is what's going to happen here. That's a prediction that I have.
ask you one other series of questions concerning sort of who did what. Your report indicates that there were, in no small part, 2 undertakings, if I can ask them in terms of pillars: the damage to the vehicle and the injuries to the body of John O'Keefe, correct?
I would say that's a fair characterization, yes.
Okay. And I may be butchering this a bit because I'm not being very scientific, but were you more responsible for the vehicle damage or the injury damage?
The vehicle damage.
And who on your team?
Also, I kept trying to pause, but it wouldn't respond. It was like, perhaps, I'm not being very scientific. What I wanted to say was, to be fair, neither was Trooper Paul, the actual expert.
Team was more responsible.
Let me go back a
for
little bit. Sorry. No, what? What just happened? What just happened here? What is going on? You know what? I have a cat that is on the keyboard. Crap. Okay. Let's see.
For the military, we do player safety for the NHL. Hope for a case factors.
And that might include everything from passenger vehicles, commercial vehicles.
Okay, no, we're past
Society
here.
of America.
Yes.
Sorry, guys,
And
I gotta find it.
engineering.
Correct.
All right. And Dr. Rentschler is a PhD in stats data
Further.
sheets for a 2021 Lexus LX
Okay.
570.
A little bit past.
So that's a fair characterization, yes.
Okay. and I may be butchering this a bit because I'm not being very scientific, but were you more responsible for the vehicle damage or the injury damage?
The vehicle damage.
And who on your team was more responsible for the injury damage?
That would be Dr. Andrew Rentschler.
Obviously, Dr. Wolfe, in coming to your opinions and conclusions concerning the damage to the vehicle, you had to consider the damage to the human being, correct, John O'Keefe?
Correct.
And as the team leader, in terms of Dr. Rentschler coming to his conclusions and opinions concerning the damage to the human being, he also had to consider the damage to the vehicle and the interplay of the two, correct?
Correct. We work together.
I was just going to say, is that how you two and Mr. Klein work together to come to the opinions and conclusions that are cited in your multi-page report?
Yes, sir.
Thank you. That's all I have, Your Honor.
Okay. Mr. Lally?
Thank you, Your Honor.
Good morning, sir.
Good morning.
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Did you specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
So you personally looked at all 14 of those items that are listed within the report?
Yes, sir.
Items that are listed within the report?
Yes, sir.
And you indicate that it was your opinions or what you did in this case, that was, you were asked to answer specific questions, correct?
Yes.
It wasn't like you were just tasked with, hey, here's some facts, go do, or take a look at a crash reconstruction or create a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think ultimately it was an open-ended question.
But related to you testified as to two specific areas that your firm or your agency looked at, right?
Those are the disciplines that the report covers, yes.
Well, you testified about some other areas of expertise as far as human factors, visibility, luminescence, things like that. You didn't do any of those things here, correct?
Wasn't part of my scope in this case.
And the scope in your case, you indicate that it was based on the evidence, correct?
That is correct.
Now, to be fair, that's based on the evidence that you were provided, correct?
Correct.
So what did Mr. Klein do?
Sorry, guys.
So
More
as
cat
a part of the engagement with the entity that ultimately retained us in this, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Rentschler's work, is that correct?
I would say assist us with the analysis, yes.
Now, obviously, your firm and your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually, as well as conclusions and opinions, things of that nature.
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based on the evidence that you were provided, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe, that was Dr. or Mr. Rentschler's area, is that fair to say?
Dr. Rentschler, yes.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
I have nothing.
Anything further, Mr. Jackson? All right, so, Doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, Your Honor, I didn't hear the court.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case, and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Okay, you said selected quantity of information. Who selected that information?
As far as I'm concerned, it would be the Department of Justice and the FBI.
All right, and they just gave you what they wanted to give you, as far as you know?
We had no say in what material was handed over to us.
Okay. All right. Thank you very much. Any questions based on my questions?
No, Your Honor.
Mr. Lally?
Just briefly, and I apologize for this. I'm just unaware. Is it Mr. Wolfe or Dr. Wolfe?
Dr. Wolfe is fine.
So, Dr. Wolfe, when you say that you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision, were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked specifically as far as biomechanically could say the injury to the back of Mr. O'Keefe's head have been caused by contact with the vehicle? How open-ended was this question?
Again, I think it relates to, is the vehicle damage consistent with the pedestrian impact, and are the injuries consistent with the pedestrian impact?
And again, the whole panoply of injuries, is that correct?
I'm sorry, what was your question?
Let me rephrase. So did anybody
Let me ask a question.
specifically ask you to determine whether or not the injuries to the back of Mr. O'Keefe's head could have been caused by a motor vehicle?
I don't know that they asked us specifically. Again, they basically asked us to perform an accident reconstruction and biomechanical analysis and basically tell them our findings, and these are our findings.
And in the materials that you reviewed, did you see anything in there of any sort of statement, suggestion, intimation, anything at all that suggested that the injuries or the fracture to the back of Mr. O'Keefe's head was caused by a motor vehicle?
In terms of direct contact?
Yes.
No, I don't believe so.
Nothing further.
Anything?
Nothing.
All right, Dr. Wolfe, you are all set, sir.
Thank you.
All right. Now we're going to get to some argument. All right. Before we actually get to that part, let's get some questions here. Sue B, question: why does the judge seem so jaded about the defense team? I mean, she's just talking to them like she's going to talk to them. The jury's not present, so there's a bit more informality, I guess, that you can say that she can have, I suppose. Daniel Evans, question: could the FBI have messed this up due to defense not being able to properly admit them? Sorry, I'm not sure I understand your question. I think that it would be the inverse, right? The FBI messing it up would mean that the defense is not. I'm sorry. I don't understand the ordering that you mean. Sarah JH, should we bet on whether or not Lally will call a trooper as a dog bite expert? Oh, man. Baz 80's question: didn't the defense have any dog bites accident reconstruction experts already? Are these replacements, or did they not feel the need to have them at the beginning? Apparently not. Apparently they didn't. John Smith, Legalbytes, why didn't Jackson reach out to a dog bite expert before the trial, having seen the picture of the arm? They could have. My guess is they probably did, just because of the overall preparation of this legal team. They probably did reach out to some people to talk to them about, a dog bite potential, and they probably just were not satisfied with the kind of testimony that they would be giving in support for one reason or another. Mike Olson, when a defense team wants an expert, or prosecution for that matter, do they go from one to another until they find one who says what they want? How can it always be opposing sides? No, this is what happens is you interview a number of experts, you ask them about, you give them the facts, you ask them about what their opinion might be. And if they say, I can't support you, then they can't support you. That's one way that you rule out a potential expert. Then there also is, there are other factors, right? You've got to make sure that they are actually qualified to give the opinion. They've got enough experience. They're impressive enough. They have the expertise. They understand what they are talking about, and that they are able to communicate that. It can be a lot harder than you think to find an expert that is able to do all of that. Buttercup 203, Bev has to decide if he can testify. Why? He late witness too. Yeah, all of the expert or proposed expert witnesses here are under the prosecution's motion to exclude, because they are arguing that they are all too late to come in, and also they're questioning their credentials and their qualifications, which is silly in my opinion. Shannon, Legalbytes of love advice. This is for baby bites. Nurse within 20 minutes, get advice training start now for pets and babies. Prevention is always best, from a mom with 4 dogs. 100%. It's something that Mr. Bites and I have been talking about quite a bit, is the adjustment of introducing a baby to the pets, and what we can do to smooth out that whole process, of course, because that's going to be a huge adjustment for all of them as well. So definitely something we've been thinking about and preparing for sure. Thank you so much. The Lucian question, they keep avoiding who hired this witness. What reasons would that be? Is it not probative? I think, I don't know exactly why they were trying to avoid saying it, but he did end up saying it. He said, DOJ and FBI is a part of the DOJ, the Department of Justice. So I'm not completely certain why he was trying to not say it. Daniel Evans question. Oh, so limited scope is okay for Lally, but not for Jackson. I'm lost. Well, that's what the prosecution's trying to do anyway, right? Bonnie Scotland, thanks so much for the super chat. I wonder if J.O.'s family will question what they've been told by the McAlberts after this guy tells what he knows. Thoughts? Maybe. I don't know. Possibly. I really don't know, what the O'Keefe family is thinking about all of this here, right? I mean, we can speculate all we want, but at the end of the day, unless we actually talk to them and have an actual conversation with these people, we really don't know what's going on in their minds. Also, a couple more here. Alex 025, what happens if you take the stand and have to use the restroom? You can always ask for a break. You can always ask for a really brief recess, because, you've been on the stand for a while, and either you need to stretch, or I don't know. So for whatever reason, you can do that. You would just turn to the judge and ask if you can take a quick break. Spunky Nuggets. Also, both defense and prosecution had the FBI witnesses' grand jury testimony. How can the judge penalize the defense under Rule 14? I don't get it. Well, I think as she hasn't determined at this point that these witnesses, the ones from Dr. Daniel Wolfe and Dr. Andrew Rentschler, she hasn't determined that those are Rule 14 violations, or at least she hasn't said that yet. So I think because she's very, very familiar with the source of how they learned about these people, that's why she seems to have distinguished between them and her. All right. And one more, Mike Olson. I'm sure it is hard work to find experts, no doubt, but in many trials, the prosecution finds an expert who says left, the defense find one who says right. Experts oppose each other. Strange. No, this is common. That's why they call it a battle of the experts. And the idea is, and how much an expert can impact the outcome of a trial, it really depends on so many things, because the jury also very often will look at what is being testified to. And, they will recognize that both sides are hired guns, the experts on both sides, and they might end up disregarding both. So that often is a very common thing as well. So, but not always. In some cases, it can make a bit of a difference. All right. Okay. Argument time. Also, 10 more likes to 500. We've got over 1,300 people in the chat right now. If you have not done so already, please do like the stream. It really does help to push this out to the algorithm gods. We get more people joining us for these streams, more people watching with us. It's always more fun with a bigger party. So if we can get that to above 500, that would be amazing. And then beyond that, how far can we get the likes in here? It really, really does help. So, and if you are enjoying this even more so and you want to support the channel, I've said this before, I'll say it again, the best way to support is by becoming a member of Byte Club, either through YouTube memberships or supporting on Patreon. Either of those are great because that helps me to be able to use the resources that I can, the time that it takes to put on the commentary and all of this stuff for covering a trial as fully as I like to do so, with live streams and recaps. That requires, having an editor so that I don't, completely exhaust myself and run myself ragged. I've done it before. I don't want to do it again, especially not when I'm, like 7 months pregnant. But it does take a lot of time and time intensive resources and other resources and all that kind of stuff. And so that really does help to support the channel 100%, so that for this trial and for the next trial and for all of the other subjects that are going to be coming our way, I want to be covering as much as possible. And continue on. And we are on the road to 250,000 subscribers. So if you are wanting to see more stuff like this, hit the subscribe button and let's continue talking about trials and other legal topics that are coming up in the news and elsewhere. And yeah, that'd be great. Thanks so much, guys. Okay. But otherwise, if you can't support, liking the video is the best thing that you can do, because that also helps with AdSense and all that great stuff. All right. Yay, we hit 500. Awesome. Okay.
I'm just going to ask you to be mindful of the court.
Oh, so we're not going to have argument yet. It's going to be Dr. Rentschler first. Okay.
You solemnly swear to the undershirt of the court in the case now and here, and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Gotcha.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Definitely.
Certainly. Dr. Andrew John Rentschler, Rentschler.
Sir, what do you do for a living?
I am a biomechanical engineer and accident reconstructionist.
In what area of the country do you live in?
I live in Pittsburgh, Pennsylvania.
What is your title currently at your company?
I am a vice president and director of biomechanics for the Midwest Division.
And what is the name of that company?
It's called ARCA LLC.
And what is the main mission of ARCA? What does ARCA do?
So ARCA is a engineering consulting company, and we have several different types of engineers, biomechanical engineers such as myself, accident reconstructionists, mechanical engineers. We look at crash worthiness, safety of vehicles, and other types of events. So we really do all types of work. We do litigation type work, as well as research and development for government and private entities as well.
Let me have just a moment, Your Honor.
Yes.
Joshua, thank you so much for gifting 5 Legalbytes memberships. You rock. That is so kind and generous of you. So Tish, Alex025.
A brief synopsis?
Alex025, sharply opinionated. Brad Hopkins, you have all been gifted memberships by, and also James Randolph, you have all been gifted memberships by Joshua. So welcome back to Byte Club. So happy to have you guys here. And thank you so much once again, Joshua.
Of the professional discipline of injury causation biomechanics. What is that?
So injury causation biomechanics is really applying traditional engineering principles to the human body. So as a biomechanical engineer, I look at the response of the body to accelerations and forces and determine how an injury occurs. An injury to the human body is just an engineering problem. For instance, a mechanical engineer might look at a piece of steel and the size of the steel and the shape of it. And if you apply a force in a certain direction, that steel will bend and eventually break. Well, we do the same thing, but we look at the human body. How much force do you have to apply, and how does that force have to be applied in what direction or manner to get a specific injury, whether it's a skull fracture, an intervertebral disc injury, a concussion. So we look at the response of the human body to different forces and accelerations in different types of settings. And ultimately, our hope is to help mitigate or prevent injuries, whether it's in a motor vehicle accident, sports setting, industrial setting, auto pedestrian impact, try and make products and environments safer for individuals.
And that's
This is what we should have gotten from Trooper Paul. Like some kind of science, some kind of physics, some kind of something, excuse me, about, what kind of force is required to create certain injuries. This is what we needed to hear. And so if we end up hearing this, if the jury ends up hearing this testimony from the defense, it's going to become incredibly apparent that they should have heard this from the prosecution. And it's just going to make their case that much weaker.
different from what medical doctors do, correct?
It is, yes, sir.
Little boy walks into an ER with a broken arm. The medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it, what's the prognosis. As a biomechanical engineer, I kind of take the reverse direction. We look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? How much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of approach the injury from two different directions.
Understood. And given that scientific approach, oftentimes you can come to conclusions and opinions, scientific conclusions and opinions about the causation of an injury, correct?
Absolutely. Yeah. And I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Brilliant. Also, Mama of Six, welcome to Bike Club. So happy to have you here. Thanks so much for supporting the channel. You rock. I hope to see you on Saturday, along with everybody else that's new to Bike Club. Saturday, 10 a.m. East Coast time, we've got our members only live stream coming up. So hope you can join us for it.
You tell the court a brief synopsis on the discipline of human factors. What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body. We have to know anatomy. We have to know the makeup of the body. And then human factors plays a part of it as well, as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
Doctor, as the director of biomechanics and human factors at ARCA, what education, training, and background qualifies you to perform those duties?
Well, I got my bachelor's of science in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD or my doctorate in bioengineering and biomechanics from the University of Pittsburgh in 2004.
It's pretty good.
Can you give us a brief work history up to and before ARCA?
Sure. So I got my PhD in 2004. And then since then, I've worked in the consulting field for biomechanics. I've worked for a company out in Davis, California for a while called Biomechanical Engineering Accident Reconstruction. I then joined another engineering company in Jacksonville, Florida for about 3 years called Chesapeake Engineering and Design. And I have now been with ARCA for approximately 16 and a half years.
And in those positions and in your position currently as a director at ARCA, do you specialize in research and analysis attendant to evaluating and studying the relationships between crash injuries, crash forces, human kinematics, and human tolerances?
I do. I mean, that's really what I do on a daily basis, whether it be in litigation type cases or the research and development we do for different companies or entities, or even internal research that we perform at ARCA.
Doctor, what professional associations and accreditations do you have?
I'm a member of the American Society for Mechanical Engineers, as well as the Society for Automotive Engineering. With respect to biomechanical engineering, there's no actual professional licensure for biomechanical engineering. So a PhD or a doctorate is the highest degree you can have in that field.
Are you also a reviewer for archives, physical medicine and rehabilitation and biomechanical engineering online?
I am, yes. Usually if you publish articles in a journal, usually that journal comes back to you and asks you to be a reviewer. So I certainly do that type of work as well.
I'd like to ask you a couple of questions about your ongoing education, your professional education after your PhD. Have you continued your education in areas of biomechanics and high impact injuries from the NTSB?
I have. I've taken classes through the NTSB and SAE, the IPTM, Police Technology Management Training Center. There's several different entities I've taken biomechanical and accident reconstruction courses through.
So the alphabet soup, if you will, of biomechanical engineering and human factors.
Right, yes.
And you continue that today?
I do, yes, sir.
Any specific training in human kinematics?
Yes, I do have training in human kinematics.
Just out of curiosity, how do you define what is kinematics?
So kinematics is the motion of the human body and looking at how the body moves. And it's irrelevant or irrespective of the forces that cause that motion. So we're really looking at for instance, how one body part moves with respect to the next. We can see how the body moves as a result of a specific type of event.
You mentioned injury mechanics previously in one of your answers. What is injury mechanics and how does that relate to biomechanics?
So again, that's a subset of biomechanics, looking at the response and the strength of the different parts of tissue of the human body. On a very basic level, to get an injury or have an injury occur, you need really two factors. You need enough force to cause injury to the tissue, and you need that force applied in the right manner. So if I wanted to fracture my elbow, I certainly couldn't take a hit on my shoulder and expect my elbow to fracture. Its force is exerted in the wrong location. And likewise, if I just lean my elbow on the counter here, that's not enough force. So you need the force and you need the application of that force in the correct manner to produce what we call an injury mechanism.
And have you ever participated in any studies or research in this area? In addition to your dissertation, getting your PhD, what about additional studies and research in this general area?
I have, yes, sir.
Can you describe that for us briefly?
Certainly. Well, just at ARCA, I've worked with the United States military. We worked on the design of the MRAP vehicles, the mine-resistant ambush-protected vehicles over in Iraq and Afghanistan.
That's a troop carrier, correct?
That's correct, yes. And the issue there is they go over the IED, the improvised explosive device, and it blows the vehicle up off the ground. So you're getting very large forces and accelerations through the vehicle, through the seat, into the soldier's spines.
Yeah.
So we're seeing very traumatic and severe spinal and head injuries. So at ARCA, we work on what we call an energy absorbing seat design. So when the vehicle gets blown off the ground, that seat is designed to absorb the force and the energy to protect the soldier's spine and their head.
That is so interesting. And now I want to ask Mr. Bytes about that to see if he has any like knowledge of like whether or not that was something that he came across or was familiar with, or what his thoughts are on that.
Part in the design of that seat.
I did, yes, sir.
Has that been employed by the Department of Defense?
Yes, it has been.
And are troops utilizing that new seat design, that safe seat design in that troop carrier to this day?
As far as I know, is from what they'll tell us, yes, sir.
Understood. Are you also published in this field, Doctor?
I am, yes.
Of course
Can you
he
give
is.
us a couple of examples of current studies that you're involved in or publications that you've done in the recent past concerning bioengineering and the impact or the association that it has with human factors?
Sure. I mean, and another project I'm working on is we work with the NHL actually at ARCA. We have an ongoing, we have an ongoing relationship with the Department of Player Safety. For instance, we helped redesign part of the rink. In every arena, they had at the end of the player area, there was basically a 90-degree stanchion where the glass met. And so players were kind of getting checked down in the boards and then hitting up against the glass. And actually, somewhat ironically, it was Chara hitting Pacioretty into the glass, the Boston-Montreal game, and caused a cervical fracture and concussion. And the NHL came to us to see if we could have a redesign of the rink to make it a little safer. So we took crash test dummies, anthropomorphic test device, which you've probably seen on TV, the automotive manufacturers use them all the time, and threw them into different configurations of glass. And now in every arena in the NHL, it is basically a curved piece of spring-loaded Lexan or plexiglass, where the players now, they hit into it, it absorbs the impact, and they glance off of the glass.
That's really cool.
Is that a design that you helped come up with?
It is, yes.
So both from the United States military as well as professional sporting leagues, they've come to you to help save lives, lower risk.
That's right, mitigate and prevent injuries, yes, sir.
What about crash and sled testing?
Yeah, I've performed a number of crash and sled tests. When you look at, any vehicle that's driven in the United States, it has to pass federal motor vehicle safety standards. There's federal regulations that they have to pass. And, part of that involves running the vehicle into a wall at 35 miles an hour, hitting it from behind, rollover type impacts. And they have these crash test dummies in those vehicles. So we perform a lot of testing for different cases and situations where we put that dummy in the vehicle and we evaluate the safety system, whether it's the lap and shoulder belt, or if it's the airbag or the seatbelt pretensioner, determine how to make the car safer. And part of that is looking at the force that's exerted on that dummy, because there's tolerance values. We know how much force it takes to cause specific injuries. So we want to make sure in certain instances, at certain speeds or impacts, that if someone's in an accident, the force acting on, say, their head or their neck or their chest is going to be below these established tolerance values.
Speaking of how much force it takes to cause an injury to a human body, have you engaged in any testing or published in the field of auto pedestrian incidents?
Yes, I've been involved in a number of studies where we're looking at auto pedestrian type impacts. Again, a lot of times we'll utilize the crash test dummy where we'll set it up and we'll actually have it struck by different vehicles or different objects to look at the response of the body. It's very important if you're talking about an auto ped type impact. You have to know the configuration of the pedestrian, the vehicle, where they hit on the vehicle, whether it's a projection type impact, a wrap, fender vault. It really all depends on how the person's positioned and the amount of force and speed involved in that type of an impact.
But sir, would you agree that in pedestrian automotive collisions that somehow physics becomes impossible to use in order to calculate where that person landed? Would you agree with that, sir? That's standard, right?
And staying with that for a second, that basic subject matter, have you also engaged in studies related to slips and falls where somebody might fall from a standing position and injure themselves either to their head, shoulders, whatever, and those kinds of injury impacts?
I have, yes. And then one of the issues we look at it there is a lot of people fall, especially elderly people. So we want to look at what types of forces are being produced. You look at hip fractures, if you slip and fall backwards, head fractures. So we're trying to determine how to prevent those falls from happening and also create devices or products that can help actually prevent injuries if someone does take a fall.
Doctor, have you been retained as an expert in the area of biomechanical engineering and human factors in the past?
I have, yes, sir.
May I approach you, Honor?
Yes.
Can you take a look at that document and tell me if you recognize it?
This is a list of my deposition and trial testimony.
Your Honor, I provided that to the court this morning.
Yes, I appreciate it. I had a chance to look at it.
Okay. That's about I don't want to go through everything. That's about a 14-page document. Is that correct?
That's correct, yes, sir.
Let me just ask it this way. How many times do you think you've been qualified as an expert in the field or testified as an expert in the field of biomechanics, biomechanical engineering, and human factors?
I've testified probably over 150 times in numerous state, federal, civil, and criminal courts throughout the country.
Your Honor, move to, I'm sorry, may I approach?
Yes.
For the purposes of voir dire, Your Honor, I would ask that this document be marked.
Sure.
Thank you.
Yeah, this is really fascinating.
Have you ever
I really
testified in criminal court? as an expert in biomechanical engineering?
I have, yes.
How recently have you testified in criminal court?
Well, actually, I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania. For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred and that they were entirely inconsistent with what would have happened during a stair fall.
What about
This guy is a wizard. He's an outright wizard. I'm so impressed with him. And yeah, I'm so fascinated by his testimony and the things. Like, I just want these guys to come in just so that I can hear what they have to say about all of this stuff. Like, I desperately want answers, and we have not gotten those answers at this point in the case. So it's like, I just want to hear from them just to hear their thoughts. Like, not even necessarily, because they're pro defense or pro prosecution. Like, I just want to get some freaking answers in this case. And I feel like these guys are very engaging, and it would be so fascinating to listen to them talk about it. Nico Kiski, you're a wizard, Andy. Exactly. Oh, man.
another case?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death, and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink, it's inconsistent with the injuries and the type of force that would have been exerted in that case.
In both of those murder cases, you were hired or retained by the prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
You gave your opinions in furtherance of the prosecution's case in chief, not the defense case in chief, correct?
That's correct, yes.
With regard to this case, you were asked to look at several items. We've already gone over those in the other testimony, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of scientific certainty?
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either?
That's correct. I was not.
It was a completely independent agency, is that right?
That is correct. Yes, sir.
Before this morning, have you and I ever met?
No, sir.
And you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further.
Okay, Mr. Lally?
Thank you, Your Honor.
Lally.
Good guess.
Just a few questions for you, sir. Good afternoon.
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by
As
confidentiality?
far as who, what, where, and how you could discuss what you did?
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
And so my question, sir, more is geared towards, at some point you were made aware that your report and your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now, May I approach, Your Honor?
Yes.
Sir, I am going to show you the first couple pages of your report, specifically right down the bottom. There's a list of items 1 through 14. I asked you to do those.
Okay.
Now, is that the totality of information that you and your firm were provided with in reference to what you did in this case?
I believe it was, yes, sir.
So nothing beyond that list of 14 things did you have occasion to look at, review, or have any opportunity to see at any time?
Well, aside from we did do testing in this case, so we did do other
Aside
work.
from your independent testing, I'm asking as far as material provided by whoever employed you, that is a sum and total of what you received, correct?
I believe that would be correct, yes, sir.
And did you personally review each of those 14 items? Because, and I don't fault you or your company for this, but within the report, there's a lot of we. So what I'm asking is, did you personally review each of those 14 items that are listed in that report?
I did personally review every bit and every page of information that was provided in this case, yes, sir.
And to be clear, just to sort of close the loop on this, when it comes to those 14 items, were you allowed to ask for any additional items, or was it just you were limited to this is what you have, go form an opinion?
There may have been discussion about if there's other information available, but I believe ultimately that we rendered our opinions obviously just on this specific information that was provided to us.
Now, as far as your opinion in your report, when was that issued?
February 12th of 2024.
So that date on the top of the report of February 12th, 2024, that's when you sent the report to the people that contracted you to do the analysis in the first place.
That's correct, yes, sir.
May I approach you?
Yes.
Thank you.
Sure.
Now, am I correct? And what I'm trying to ascertain here, Doctor, is just sort of the different roles that you and the other members of your team performed in reference to this. Am I correct in that your primary role in this pertained to the sort of biomechanical engineering analysis of injuries sustained by Mr. O'Keefe?
That would be correct, yes, sir.
And not to put too fine a point on it, but Dr. Wolfe would have been more responsible for issues related to the vehicle itself.
Generally speaking, yes, that would be correct.
Obviously, there's some interaction between damage to the vehicle and injuries to Mr. O'Keefe, but as far as your primary sort of any opinions contained within this report pertaining to injuries to Mr. O'Keefe, those would be your opinions, correct?
Yes, any opinions or information with respect to the injuries would be my purview and my opinions in this matter, yes, sir.
And concomitantly, so any opinions related to damage to the motor vehicle, those would be opinions of Dr. Wolfe, is that right?
Well, to some extent. I mean, certainly I would have opinions as well based on the interaction or alleged interaction between the body and, for instance, the vehicle in this case, and what damage to both the body as well as the vehicle you would expect. So I think there's basically some overlap between those issues. I wouldn't say that it's a complete separation.
And so, and again, Doctor, what your opinions or ultimate conclusions are, whether they be yours or Dr. Wolfe's or a combination of the two, it's all limited based on the information and the evidence that you received, correct?
It certainly is based on the information that we reviewed and listed in our report. Yes, sir.
Now, as far as sort of a mandate or from the agency that hired you, were you asked to answer a specific question, or were you asked to just do an analysis based on what we sent you, or how was that put to you as far as what you were doing?
There was a specific request that we were asked to perform and to evaluate in this case.
And specifically what I'm asking, sir, is there's an analysis in there of whether or not the injuries to the back of Mr. O'Keefe's head could have been caused from contact with the vehicle, correct?
That is part of my analysis and opinions, yes, sir.
And were you specifically asked to address or answer that question by the agency that hired you?
That was one of the questions I was specifically asked, yes, sir.
I have nothing further.
Anything further, Mr. Jackson?
Your Honor, thank you.
All right, so Doctor, I have a couple of questions for you, sir. So regarding the specific request, what
Hang on. My earbud died, but it's convenient timing because I can update the thing here, the thingity thing. Okay. And also, sorry, let me change out my earbud so we can get back to it.
were you tasked to do specifically?
So specifically overall, I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred. And part of that was determine whether the injuries, the head injury and the arm injuries resulted from contact with the Lexus in this case.
Okay. And regarding all of your prior testimony, a good deal of it seems to be in depositions. Any of those in Massachusetts?
There's a couple, I believe. I've testified at trial in Massachusetts,
Okay.
Middlesex Superior Court.
Do you know where that might be? I do want to look at that.
I can find it for you, maybe a couple of months ago.
Was it in a criminal case or a civil case?
Oh, it was in civil case. I
Okay.
think, let's see here. I think, yeah. So let's see. There was one November 14th, 15th, 2023, Middlesex Superior Court. That was probably the most recent one.
Hey, what number is that on there if I want to go
that
back and look at it?
That is number 310.
Thank you. Is there another Massachusetts case?
Oh, I'm sure there are because I know there's some from earlier in my career. Let me see. See if I can find them for you real quickly here. Read this. So there's Connecticut. That was with Louisiana.
Can we get to 650 likes? Thank you so much for that, Mountain Princess 207.
Oh, there's 68. I'm gonna butcher it. Worcester.
Is that a civil or criminal case, Doctor?
That is a civil case as well.
Okay. What year was that?
Oh, that one was 2012.
Okay.
So I think she wants to go and look at the depositions that he
Any others that
testified
you
in.
think of or you see?
There may have been a couple others. I don't recall off the top.
All right, I'll go through it more closely. I
Sure.
appreciate you saving me some time.
Absolutely.
All right, any questions based on my questions?
No, thank you, Your Honor.
No. All right, you are all set, sir. Thank you very much.
Thank you, Your Honor.
Now will there be? Mountain Princess 207. I am loving the auctioneer state that you are that you're getting these likes in. Can we hit 700 likes? Can we get 700? I hear 600. Can we get 650?
All
I see
right,
650.
so
Can we get 700?
Mr. Lally, I will hear you on your motion. Now, we didn't get into the ultimate opinions and the basis for that opinion, but I'll hear you on your motion.
Your Honor, what essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it? There's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think very simply what the Commonwealth had been seeking for the most part was covered today.
Okay. All right, I have some questions as to the scope of the testimony of the witnesses. So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report,
Correct.
and the conclusions, all 4 conclusions in the report?
Correct.
All right, Mr. Lally, what's your take on this?
Oh. Should not have unpinned that.
I do have an issue with number 4. I don't think they're qualified to testify to. I don't think either of them is qualified to testify to that. That's more of an area of forensic pathology.
What do you
What's
say to
number
that,
4?
Mr. Jackson?
What's number 4?
Number 4 is, their opinion is, there is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull brain injuries or the circumstances surrounding the event. That is well within the scope of their expertise, obviously. I don't think I have to beat this dead horse. They are highly, highly qualified to render all 4 opinions. And if the evidence in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidenced here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within it's well within the scope of what they can testify to. That's their opinion, that's their conclusion. Mr. Lally is going to have an expert, Trooper Paul, who is going to differ, or who has differed in that opinion. So be it.
And I would have kept it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
I think we're talking about 2 different things, apples and oranges. That's not, Trooper Paul's opinion is that his injury or his injuries, or I think he said variously that it was blunt force, could have come from the curb, or it was blunt force because the road is blunt. That
is what he
his
said.
opinion, and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion and opinion that the evidence is insufficient to support that determination, and it's well within their purview to testify to that.
If I may, I don't think that's their actual opinion. I initially didn't think of it in these terms as it's phrased on the cover page of the report. If you look at the actual opinion
I
and
was looking at
findings,
the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's consistent with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but I'm sure you all could use the afternoon to prepare. All right, Mr. Lally, let me know Thursday if you need, are you ready to go forward at least with your case on Thursday?
Oh, yeah, sure.
Let me know Thursday if you need additional time. If I let Dr. Russell testify, how that impacts our schedule. Okay?
Absolutely. Your Honor.
All right, but I don't want that to be a concern of yours, how it impacts the schedule. That's my concern. I just need to know. All right, so anything else?
For the Commonwealth.
I think that's it. Thank you.
Okay, we'll see you Thursday morning.
All right.
Court will rise.
Thursday morning it is. And up to the fan. Okay. Once it gets there, we are set. That's the end. Okay. Let's get some questions really quick and then we will wrap it up and we will see each other on Thursday morning, East Coast time. But first, let's do these questions. And also, before anybody has to remind me, this time I remembered, I am going to close out the poll right now. Boom, I remembered without needing to be reminded. On day 27, how do you lead in regarding KR's murder charge? 86% said not guilty. 9% said need more information. 4% said guilty. So very interesting. Very, very interesting. All right, let's get some questions here. Matt Lubis, off topic. You're going to cover the Delphi murders trial. That depends on timing. I haven't been paying as close attention to that one. That one's another one that I've been sort of loosely hearing about, and it's interesting. That also I think is going to be a long one. It depends partially on the timing because baby bites. So, like there's the Donna Adelson trial is supposed to be the end of September. So that one is like a maybe for me, maybe because I should be a mom by then, and so it entirely depends on how all of that goes. The huge transition in the Bites household, obviously, but I also have an interest in covering this stuff because I have a real fascination for this stuff. So yeah. So anyhow, we'll see. Same thing with Delphi murders, depends on partially when it is, if it's interfering with other trials that I already know that I want to cover. Yeah. Larry Huffin, Alita, I would also like to say thank you for not taking out the stuff that makes YouTube demonetize you. I know you're taking a hit on that, but I really appreciate you letting us hear the truth. Absolutely. I mean, that's a given in these cases is, when there's something, when there's something that is like could get me a strike because, there's images that could be interpreted as illicit images of children or things like that. There have been some cases where I've had to really run defense on stuff like that. I'm going to be very, very careful about that and shielding that, because that can get your entire channel taken down. But otherwise, where it's just offensive language, things like that YouTube doesn't like, but that is, it's not going to have the worst impact on the channel, like getting a strike, things like that. That's I would much rather just have the accuracy of the trial and testimony and everything and not try to limit it to the extent that I can. Geeky Geeka UK, Geeka or Geeky Edge UK, Geek A UK. One of those I hope is right. So can we just ask him if there's any circumstance under which it's possible to be struck on the arm so that you're thrown 30 feet without sustaining any fractures or bruises? I would love to know the answer to that as well. Heather S., do most PDs use their own officers with training of sorts to do engineering/material science analysis? They don't hire STEM people to work at the PD like they do with medical examiner, MDs, forensics. I don't know. I don't know exactly how common it is for accident reconstructionists. I want to say that most of them use the police department for that, at least part of the expertise in that. And maybe they bring in a secondary one who can give more like deep level nuanced kind of testimony. But I'm not entirely sure. I haven't done criminal law myself. My experience is in civil litigation. So, other than watching these trials, commenting on these trials, and also learning from other people that I know, friends that I have that are in criminal law, things like that. So I don't know. I can't give you a more precise answer on that one. Tish, Legalbytes, why is the judge asking these questions and why doesn't she ask for the same information from all witnesses? Well, to be fair, she is looking for different information. She's looking for different information because she has different concerns about these different witnesses, I think. So I think that's why she's asking some different questions. Sheena Ford, Legalbytes, is she putting everything she has with her legal team money? Lally is probably on a tight budget. I agree. I think that she has resources that a lot of people do not have or would not have in a similar case. And I think that has an impact. And also the DA is limited on what kind of resources they can use. So, but that doesn't mean that they can't work to hire, some kind of experts to combat it, particularly because it's a high profile case, Darth Horse, Legalbytes, do we know what the report says yet or waiting to get it put into evidence? So the reports, I don't know. I think you're probably referring to the medical examiner reports. I don't know what those say personally. There might be other people that have been following this case much longer that do know. So, I'm going to find out when the jury finds out. So yeah. Emmanuel Secco, Legalbytes, these experts are impressive. However, the scene has not spoken to them. I know that's a serious limitation on their testimony and on their expertise and on their opinions. How can we rely on their opinions if they did not have a full-on conversation with the crime scene? Tweakins, thank you so much for becoming a new member of Bite Club. Welcome to Bite Club. So happy to have you here. Thank you so much for becoming a supporter of the channel. This really, really, really helps. All righty. Okay, that is the last of it. We are all caught up on questions. And I think that's about it. We're gonna head out now. This has been great. Thank you so much for joining me on this day of not testimony, but voir dire. This has been fascinating to hear what kind of expertise these guys have that are hopefully going to be brought in as experts. I really hope that they do decide to bring them in because I'm just fascinating to hear their thoughts on the case. Really, like that's basically it is founded in a serious curiosity on their thoughts based on how they've talked about the other stuff that they've come across before. I think it's going to be fascinating if they do testify. I think that it's going to be engaging based on the ways that they responded on voir dire. All of them, all three of them today. I hope they all come in. All right. That's everything. Thank you so much, everyone. Thanks so much for joining. Thank you all the people that have joined Bite Club and are supporting the channel. Thank you to everybody who are or bought memberships for other people. Thank you to the folks who super chatted. Thank you for joining me, for engaging in the chat, and for you leaving comments on the replay, and also for liking the video. Amazing, amazing stuff. Let's see. Let me refresh here. How far? We have 732 likes. Amazing. We got over 700. That's amazing. Thank you so much, you guys. That is super, super helpful. The more this stuff, the more people engage with the stuff, the more YouTube recognizes it and pushes it out to more people. So, alrighty, guys. That'll about do it. We will have the recap from day 26. Should be coming out very, very soon today. Maybe shortly. I've got to check up on a couple things. But other than that, look for a recap tomorrow for this voir dire for day 27. And I'm also going to try to get a video out that has nothing to do with the Karen Read trial, because I want folks to know that there are also other topics that we cover in this case, not just Karen Read. And hopefully that'll be interesting for you as well. So keep an eye out for that as well. And then, of course, we will be coming back on Thursday morning East Coast time for day 28 of this trial. Will we see the end of the prosecution's case in chief? Will we see the end of it? It is near. Is it going to be Thursday? Is it going to be Friday? We will see. Will we hit 2,000 what if any's on Thursday? We'll find out. Thanks again, of course, to the mods for also helping with the chat and making sure that this community is the awesome community that we have, with all the people coming in and engaging and bringing in their thoughts and different perspectives. Love it. Love to see it. Okay, guys, that is it for me. I'll see you in the next one.